Mr. McRae, this is your preliminary hearing, sir, and I want to just advise you that anything you say during this proceeding is not going to be private or privileged. So please don't say anything you wouldn't want the whole world to know, okay? All right, this is case number 29 on my calendar, State of Georgia versus Todd G. Adonis McRae. He's charged in warrant number 2021 WA 18599 with committing the offense of terroristic threats or acts as a misdemeanor. He's charged in warrant number 2021 WA 18600 with committing the same act of terroristic threats or acts, and he's charged in warrant number 2021 WA 18601 with committing the offense of simple assault. Ms. Ponder, you may proceed. Swear your witness in, and you may proceed.
Yes, officer, will you please raise your right hand? Do you swear or affirm that the testimony that you're about to give in this matter, the state versus, apologize, Taraji McRae, is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can place your hand down. May you please state your first and last name for the record, please?
Yes, my name is Gregory Tillman.
And Officer Tillman, how are you currently employed?
I'm a police officer with the Clayton County Police Department.
And how long have you been employed with the Clayton County Police Department?
Approximately 5 years.
And been employed with the Clayton County Police Department, does that require you to be post-certified?
Yes, ma'am.
And are you currently post-certified?
Yes, ma'am.
And does being post-certified, does that give you the ability to have arrest powers?
Yes, ma'am.
Now I want to bring your attention to October 27th, 2021. Do you recall that date?
Yes, ma'am.
And on this particular day, were you employed with the Clayton County Police Department?
Yes, ma'am.
And on this particular day, were you in fact post-certified?
Yes, ma'am.
And on this, did you respond to 10891 Terra Village Way, Jonesboro, Georgia?
Yes, ma'am.
And is that located here in Clayton County?
Yes, ma'am.
And when you arrived to this incident location, what was the reason that you arrived to this location?
Yes, I was called. We received a call from Mr. Artis McRae, who is Tajai or Tarat. I'm not sure how to pronounce his name, but he's his father. He called because his son was at the residence and he was saying he wasn't supposed to be there.
And when you arrived on scene, did you make contact with the Artis McRae, the father?
Yes, ma'am.
And at any point, did you make contact with someone by the name of Tajai or Tajai McRae?
Yes, ma'am.
And for identification purposes, did you make physical contact with that individual on this day?
Yes, ma'am.
Okay. And are you able to identify that individual with an article of clothing or for a physical description for the record?
Yes, he has on a jumpsuit with a mask.
And what color mask, Officer Tillman?
It's a white mask.
At this time, let the record reflect that the witness has identified the defendant, Mr. Tajai McRae. And Officer Tillman, what information at the time of this incident that during your course of investigation did you receive from Mr. Artis McRae?
Yeah. He called stating that he had received a temporary protective order against his son and that the son wasn't supposed to be at the location. But while he was there, Tajai made threats to both him and his wife, Christina McRae, made threats to harm both of them, as well as was banging on his car door while he was in his car, which made him believe that Tajai was going to attack him.
And what statements did the defendant, Mr. Tajai McRae, state to the victims in this case?
Yes. Okay. Ty J did make a statement to beat Artis's ass, as well as he made a statement to Christina to palm her in the face.
And at that time, did any victim inform you whether or not they were in fear?
Yes, ma'am.
And during the course of your investigation, did Mr. Tajay McRae enter the home?
During the investigation, no, he did not. He had entered the residence prior to me being at the location.
And did he and were you able to retrieve that TPO order from Mr. Artis McRae?
Yes, ma'am, I did. The TPO wasn't active yet. It hadn't been served. So while I was at the location, I did serve Ty J the TPO.
And do you recall if there was any damage to any property during your course of investigation?
Yes, there was a door that led from the garage to inside the house that had damage, I believe, on the door frame.
And do you recall, in fact, how much approximately would the damage actually cost to be repaired to that particular door?
I don't remember the exact amount, but I believe it was less than $500.
And also, did you speak to Mr. Tajay McRae?
Yes, ma'am.
And what did he inform you?
Yes, he did inform that he came back to the residence because that was his last known living residence. He said that when Artis and Christina arrived at the location, he told me that he did make threats to both of them.
At any time, did he inform you whether or not he attempted to gain entry into the back door or the door of the home?
Yes, ma'am.
And at that point, during the conclusion of your investigation, what did you do?
Based on statements from everyone that Ty J did make threats to both Artis and Christina, as well as statements from both Artis and Christina that Artis felt like he was in fear of receiving an injury from Ty J, I arrested Ty J for 2 counts of terroristic threats and 1 count of simple assault family violence.
No further questions from this witness, Your Honor.
Ms. Gross?
Officer, I just want to clarify. So prior to the day of this incident, Mr. McRae, Tajay McRae, was a resident at that location. Is that correct?
Yes, my understanding was prior to my arrival, there had been no type of eviction or anything that showed that Ty J wasn't supposed to be at the residence.
So he was still a legal resident of that location at the time that you first arrived on the scene?
Yes, ma'am.
And was there any conversation about whether or not he had been allowed back into his residence at that point?
I'm sorry, can you re-ask that question?
Yes. Was there any statement by his father or his mother or Mr. McRae about whether or not anyone had allowed him back into his residence at that point?
No. From what speaking to Artis, he said that they hadn't been at the residence specifically to avoid any kind of confrontation with Ty J. And Ty J told me that he didn't have a key to the residence at that time.
Okay, so he had had some sort of conversation with his parents about the fact that he was back at the residence?
I don't believe so. I don't remember anyone saying anything about a conversation about him going inside the home.
But you said that the parents were staying away because he was there. So obviously in some way or another, they knew he was at the residence.
Possibly, I'm not sure.
Okay, but they didn't make any statements to you about that, but they did tell you that they had been staying away because he was present?
I believe specifically they said that they were staying away to make sure there wasn't any kind of incident because they knew that he would come back.
Okay. And you said he didn't have a key, so he didn't have any way to gain access to the residence. Is that correct?
Yes, ma'am.
Okay. And so you said he did make entry into the home through the garage. He told you he made entry through the garage door?
Yes, ma'am.
Okay. Now, when you arrived on the scene, was he present at the residence, or did you have to call him back from somewhere else?
No, he was at the location.
And where was he? Was he inside the residence or was he inside the garage?
He was on the front yard.
In the front yard. Okay.
Yes, ma'am.
Okay. And when he told you that he had made comments to his father and mother, was there any conversation about when that had occurred?
It was not too long before, or possibly, I believe it was a few hours, maybe an hour prior to my arrival.
Okay. And did he tell you what the context of those comments were? Were they in an argument? Were they discussing something?
I believe when our Artis and Christina told me that they had arrived at the location, and he was already irate and upset and made the statements to them. Ty J stated that he wanted to talk to them, but he did state that he made the threats towards both of them.
Okay. Was he irate and upset because he couldn't get into his residence? Did they tell you what the argument was about?
I don't recall.
Okay. All right, that's all the questions I have, Your Honor. Thank you.
Okay, any follow-up, Ms. Ponder?
Not from the state, Your Honor.
Okay, may this officer be excused?
Yes, Your Honor. Officer Tillman may be excused. State has no other witnesses and rest this time.
Officer Tillman, you are free to go, sir.
Thank you, sir.
Do we have any argument?
Your Honor, I'll just make a brief argument. So Mr. McRae, although there was some conversation about a TPO, that TPO had not been served. And so Mr. McRae was at his lawful residence. However, he did not have a key. His family would not return, and therefore he was stuck in the garage. He was being basically denied access to his residence by his parents. We've heard the testimony as far as Mr. McRae being angry with his parents and making comments to them. However, I believe in the context of the fact that he was being unlawfully prevented from going into his home, that he would have some sort of excuse for being angry with the persons who are preventing him from being able to go into his home and retrieve his belongings. So other than that, I'll just leave it to the court's discretion.
Ms. Ponder?
Your Honor, as the court was able to hear testimony from Officer Tillman, although defense is stating that he was being denied access, it does not, being denied access doesn't give you the right to threaten or place someone in reasonable amount of fear. Your Honor, you've heard from Officer Tillman indicating that not only did he receive information from the victims in this case, but he also actually received statements in which the defendant, Mr. McRae, did in fact admit that he did make those threatening statements, and statements in which he will beat his father's ass. He will also palm his mother's face and also place him in fear. And so the state would argue that there is enough probable cause for this case to be transferred over to state court.
Okay, I heard evidence to make out the elements of the terroristic threats or acts as it relates to the two alleged victims, and the allegation of approaching the car, hitting the car, whatever, that would support simple assault. So I'm going to bind all three charges over to state court.
Thank you, Your Honor.
I don't think being angry is an excuse, or can be used as a justification in this case, but see what happens when it gets to the next court. Mr. McRae is free to go back. What's the next case?
Your Honor, if I can ask a question just really briefly about Mr. McRae. Do you need for someone to present you an order binding the case over, or do you have paperwork that will handle that?
No, please present it to me. because I do not have that.
Okay, so where cases are bound over, do you want the state to prepare that paperwork or do you want us to?
Where it's bound over, the state, I think, can submit that. So Ms. Ponder, do you have, actually, Ms. Gross, the last time I used the bind over orders that I got from your office and started using those. So I think I still have it and I can prepare it. Just so that we can get this stuff moving in the right direction.
And Your Honor, if you like, I mean, I'll be happy to forward one of those orders to Ms. Ponder if you want her to use that.
Please forward it to me with Ms. Ponder being copied. And then that way I can, when this is over, I can start doing clerical work.
Yes, Your Honor, I'll take care of that.
Thank you. Mr. McRae, sir, you're free to go back. So I think we're going to have Mr. Mejia Nunez next.
Yes, sir.
I saw Miss Bermudez.
Your Honor, he speaks English. I didn't have any trouble when I spoke with him before. I mean, we can always ask him if he needs it for the legal language, but I didn't have.
Yes, I mean that I remember his case from first appearance, and I think Miss Tolles was there the last time that we were present. Mr. Mejia Nunez, sir, the last time that we were here, I made the error in not hearing the misdemeanor charges, because I thought that they were all going to be heard the next day with the felony charges. But through the efforts of your counsel, we've gotten you back on a calendar to deal with these misdemeanor charges. When Ms. Ponder comes back up, we'll be ready to go with your case. Okay. So as I think I've told you before, Mr. Mejia Nunez, none of this is private or privileged, so please don't say anything that you would not want the whole world to hear. This is going to be case of State of Georgia versus Victor Alonzo Mejia Nunez. He's charged in warrant number 2021 CW 54388 with the allegation of committing the offense of criminal trespass. And he's also charged in warrant number 2021 CW 54389 with committing the offense of criminal trespass also. Ms. Ponder, you may swear your witness in and begin your examination.
Officer Thomas, please raise your right hand, please. Do you swear or affirm that the testimony that you're about to give in this matter, State versus Mr. Mejia Nunez, is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
May you please state your first and last name for the record, please?
Dante Thomas.
And Officer Thomas, how are you currently employed?
A uniformed police officer for Clayton County Police Department.
And how long have you been employed with the Clayton County Police Department?
This month marks 2 years.
And being employed with the Clayton County Police Department, does it give you the ability to, are you post-certified?
Yes, ma'am.
Okay. And being post-certified, does that give you the ability to have arrest powers?
Yes, ma'am.
And I want to bring your attention to September the 9th, 2021. On this particular incident date, were you in fact post-certified?
Yes, ma'am.
And did you respond on this particular date to 211 Monterey Circle, Jonesboro, Georgia?
Yes, ma'am.
And is that located here in Clayton County, Georgia?
Yes, ma'am.
And why were you actually called to this incident location?
I was called to the incident location by Miss Johnson. It was a disturbance call. When I arrived at the location, I made contact with Miss Johnson, and she stated that on the day that we arrived, that was on the 9th, that her boyfriend's brother was beating on her front door with a baseball bat. She stated that on the 6th that the two brothers got in an altercation, but it was in Spanish, but she couldn't make out what they were saying. She stated that when she walked into the room, when she heard a gunshot, she said she walked into the room to see if everything was all right.
All right, Officer Thomas, and I want to bring it back some to, and you indicated it is I'm sorry, what was the victim name again? I heard last name Johnson.
Yes, ma'am. It was two victims. The first one was Miss Danita Johnson.
Okay.
Danette Johnson.
Okay, and so Ms. Johnson indicated that her boyfriend's brother was hitting on the front door with a baseball bat. Is that correct?
Yes, ma'am.
And was there any damage done to the door?
Yes, ma'am. There were 2 dents imprinted on the door caused by the bat.
Okay, and do you recall how much the damage was to the door?
She stated an estimated guess was 250, under 500.
So it's under the amount of 500. And do you know if he had any type of permission to be on the property or the premises of the home?
No, ma'am.
And did you make contact with that individual, her boyfriend's brother?
He was not on the scene when I arrived.
And at any point did you have a positive identification of who that individual was?
Through verbal testimony through his brother and his brother's girlfriend.
And did you use any type of resources in order to identify that individual?
I went on local to and booking photos to identify the individual.
And was there any confirmation of who that person was?
Yes.
And if you had to, would you be able to identify that individual with an article of clothing and a brief description of their physical appearance for the court?
No, ma'am. No information of clothing, only that he wore black.
No, I'm saying if you're able to identify that individual today by an article of clothing, would you be able to positively identify that individual with an article of clothing today?
No, ma'am.
And are you able to see everyone on the Zoom call or no?
Oh, yes, ma'am. I can see everyone.
Okay. And you're unable to identify that individual?
Mr.
Based on the booking
Victor.
photo, I guess.
Okay. Well, he got the mask on, but he does have those tattoos stated on his head.
And are you able to identify the color of mask and article of clothing that the individual has on?
A white mask, and I believe that is a red or orange jumpsuit that he has on with a white t-shirt.
Let the record reflect that the witness has identified the defendant. And during your as the investigation continued, what ultimately did you do at the conclusion of your investigation?
Could you restate the question, ma'am?
At the conclusion of your investigation, what did you determine? What happened as a result of your investigation?
Well, I've observed and noticed the damages to the door that both victims stated that was caused by the suspect. We also me and myself and other officers also noticed a gunshot hole in the wall, but no shell casing was found. Miss Johnson stated that the suspect pointed the gun directly at us as cause as aggravated assault, and the other was the gunshot discharge, 2 counts of aggravated assault. We got a statement from Miss Johnson, but we could not get one from the secondary victim Mr. Corellis. We couldn't get one from him because he didn't want to be involved in that situation.
Okay, and so just so that I can understand clearly, there was damage to the front door, but also there was damage to a wall, like a bullet hole.
Yes, ma'am.
Is that correct? Okay. No further questions from this witness, Your Honor.
Ms. Gross?
Yes, thank you, Your Honor. Officer, I just need some clarification, please. So you went to the residence and you spoke with the alleged victim, and she told you the person who had committed the offense was Mr. Nunez. Is that correct?
Yes, ma'am.
And after doing that, you went back to the station and pulled booking photos? Is that correct?
Oh, no, no, ma'am. We have, we use MCT. I also had assistance from one of my sergeants, so we use our MCT and local to pull up photos.
Okay, and so you pulled up those photos, and who did you show those photos to, if anyone?
What it was my sergeant showed it to me because we actually identified who the suspect was due by the name that was given to us by the brother, by his brother.
So the alleged victim gave you a name. You pulled up a photo that matched that name, but you did not show those photos to the alleged victim.
That I cannot recall.
Okay, so basically, when you identified what was listed as you identified the defendant, all you were doing is identifying the person who matches the photograph that you saw that matched a particular name. Is that correct? That was confusing. I'll rephrase it.
Yeah, it was sort of confusing. Can you rephrase it again?
Yes, I can. Okay, so earlier you identified the defendant as having been the person involved in this incident, and you identified it by looking at him here in the courtroom, the virtual courtroom, correct?
Yes, ma'am. Yes, ma'am.
But really all you were doing at that point was identifying the person who was in a photo shown to you by the police department as matching the name of the person who was alleged to have been in this incident.
Yes, ma'am. And with that photo came information will match both of their addresses are the same.
Okay. But that information came through the police department and not through the victim. Correct?
Came through our MCT, but the information that was gathered was help from my sergeant. So.
Okay, I understand. All right. So, officer, when you first spoke with the victim, Ms. Johnson, she told you that she heard someone beating on the door. Is that correct?
Yes, ma'am. Yes, ma'am.
But she was inside when that occurred, correct?
Yes, ma'am.
Okay. And did she tell you how many people were outside when she went outside?
She did not.
She did not. Okay. So she didn't tell you there was another individual present with Mr. Mejia?
Not to my knowledge, that I can recall.
Did she tell you at any time that she saw Mr. Mejia beating on the door with a bat?
She said that she heard him, but my thing is that they gave a description of black clothing, but she stated that it was a bat. Her and the other victim.
Okay, I understand that she said she heard someone beating on the door with a bat, and then she went outside, and her statement was that she believed it was Mr. Mejia. But my question to you is, did she tell you that she saw Mr. Mejia actually beating on the door with a bat?
No.
And did she tell you what the nature was of her relationship with Mr. Mejia? I can be more specific if you need. Did they get along? Were they friends? Were they, was there difficulty between them prior to that day?
That wasn't stated. From that, only thing they stated was like they been in a few arguments, I guess, because she was dating her brother. But as far as the relationship, is not really known to how those two got along. Okay,
but she did tell you that she had arguments with him before.
Yes, ma'am.
Okay. And you stated that Mr. Mejia Nunez's brother did not want to make a statement and did not want to be in any way involved. Is that correct?
Yes, ma'am. He stated that he didn't want to write a statement.
Okay. Did you speak with him verbally about anything?
Yes, ma'am, I did.
Okay. Did he tell you that he had seen Mr. Mejia Nunez actually hit the door with a bat?
No, he was stating that he was in the room, but he walked out and he just heard somebody beating on the door with the sound was a bat.
Did he talk to you about whether or not there was anyone else present at the front door?
No, ma'am.
And the damage to the front door was the only damage to the residence, is that correct?
The damage to the front door and the incident that happened on the 6th was that gunshot, hole in the wall of the gunshot.
Okay. The incident on the 6th where there was damage to the wall, that's part of the felony aggravated assault charges, is that correct? Or that happened on a separate day?
Yeah, that happened on a separate day. But the damages to the door occurred, as the complainant / victim stated, happened on the 11th.
Okay. Okay. All right, that's all the questions I
Sorry,
have.
on the 9th. Okay, I got you.
I'm sorry, was that a correction to the date?
I'm sorry, it was an error. It took place on the 9th. I'm sorry.
Okay. Okay, that's all the questions I have. Thank you.
Any follow-up, Ms. Ponder?
Briefly, Your Honor. So Officer Thomas, so essentially there was 2 incident dates. My understanding that you indicated on cross, I have a September the 9th and also September the 6th. Is that correct?
Yes, ma'am.
Okay. And during your investigation, you learned that both incidents from September the 6th was the same individual that came back on September the 9th. Is that correct?
Yes, ma'am.
Okay. And the information that you received from the victims in this case, how are you able to pull up any type of identification or booking photo? What information you were provided in order to get this photo of an individual?
The name and date of birth of the suspect by the brother.
Okay, by the brother. And so the brother was able to make contact with his brother on September the 6th as well. Is that correct?
From what they've stated, they were inside of the house, and I guess they had like a heated conversation which was stated by the complainant, but it was in Spanish, so she didn't really understand what they were talking about.
Okay. And so that's, I'm speaking of the incident from September the 6th. It appears that based on your testimony that that's the same individual that came back on September the 9th, the date that we're speaking of today. Is that correct?
Yes, ma'am.
And were there any other identification or any photos that came back to that name and or date of birth?
The photo that came back, it's the same photo. He just had a different hairstyle. The suspect had a different hairstyle. But I'm looking at the tattoos on his head that was stated that's in the photos.
Okay. And this particular system that you all use, in order to retrieve any local or booking photo, do you know anything about this particular system?
We know we just use it to gather information. Like if a person gives us just a name or nothing comes back, but if they give us a date of birth, if they've been booked before, we can just pull up any photos of them. If they've been in trouble with the law, we can just pull anything up.
So you're able to use this system in order to retrieve information to make a identification or to ID someone?
Yes, ma'am.
No further questions from this witness, Your Honor.
Any recross?
No, Your Honor.
Okay. I just have one question because it's unclear in my mind. How was Mr. Mejia Nunez identified as the person who committed these two offenses of criminal trespass?
Well, the two offenses from the criminal trespass is that, if I can recall, it stated that if he was speaking through the door to the victim, the two victims.
Okay.
And yes,
Okay. Any other questions based upon my question of Officer Thomas?
Now from the state, Your Honor.
No, Your Honor.
Okay. Any may Officer Thomas be excused?
Yes, Your Honor.
Okay.
Oh, sure.
Sir, you are excused. Have a good day.
thanks, sir.
You're welcome. Any argument?
Briefly, Your Honor, it basically comes down to identification, both identification in court. This police officer is only able to testify that the person standing before us is someone he saw in a picture who matched a name. If they had simply shown that photograph to the alleged victim could have identified that that was the person who had actually committed the alleged offense or had been at their residence, but the officer didn't do that. And so all he really had was a name, and then he used that name to find a picture, and all he can do is tell you that this is the person that was in the picture. That is not identification that this person standing before you is the individual who was at the residence on that evening. So we would argue that the in-court identification is insufficient, but also that the identification on the night of the incident is insufficient. The police officer stated that he was told by the alleged victim that someone hit the front door with a bat. No one saw that happen, so no one can say for sure who it was that hit the front door with the bat. They simply heard it. And when they went outside, they found Mr. Mejia Nunez, and there's no discussion about who else was outside with him. So I believe that there's insufficient evidence that Mr. Mejia Nunez was the person at the front door who even hit the front door in the first place with the bat. So we would ask that these charges be dismissed.
Ms. Ponder?
Your Honor, you've heard testimony from Officer Thomas regarding identification, Your Honor. I believe that would be a question of the jury whether or not Mr. Nunez, and I apologize if I'm pronouncing his name wrong, was actually the person. However, the officer did testify that an incident had occurred on September the 6th with the same victims, in which the victims believed that, in fact, based on that incident, he came back on September, 3 days later, September the 9th. Also, the officer testified that based on voice recognition, that in fact, that was the defendant outside the home. The brother actually is familiar. It is certain that the brother would be familiar with his own family member or his brother in which an incident had occurred. He was able to provide officers with his first and last name and date of birth. Officer Thomas did indicate that although his hair was different than what was on the photo, he does recognize tattoos, whether they were on his face, on his neck, or on his person. He did recognize that. He did indicate that the system that law enforcement officers use, his agency used, they use that in order to confirm or to make some form of identification once information is provided. Officer Thomas did not say that there were multiple individuals that popped up under that particular name or any aliases of anything of that nature. And he was able to speak with the victims. And although that the brother, the victim did not want to make a statement, he did speak with both, and that they were able to give that information to law enforcement. Furthermore, Your Honor, it appears that there was damage under the amount of $500. The officer indicated that there was approximately maybe $250 damage, in which resulted in the defendant hitting the door with the baseball bat. Furthermore, there appears to be damage in the wall from a bullet hole wound or a gunshot wound that it is stated that the defendant did do. So with that information, Your Honor, the state will argue that there is probable cause to bound these cases over to state courts.
Okay. The in-court identification thing is not really something that I put a whole lot of weight on, because there's one person standing before the camera. And at least this officer, to his credit, said he couldn't identify him, except for the tattoos. That's something that I just think is overly suggestive, to try to make an identification under these circumstances. I'm going to bind both of these charges over to state court. I believe there's sufficient evidence under the preponderance standard that Mr. Nunez may have been the person that committed this offense, and I'm relying primarily on the fact that I believe the person that he was having the alleged difficulties with, is the girlfriend or is in some type of relationship with his brother. Whether that's going to meet the standard of beyond a reasonable doubt later, I don't know. But at this stage, I'm going to bind the case over as to both charges. Mr. Nunez is free to go back. Mr. I see that you may want to say something, Mr. Nunez. I would caution you that may not be a good idea. I don't know what you want to say.
Mr. Nunez, would it be okay if I just come talk to you when the judge is done with the hearing? Okay.
Okay. All right. Thank you. All right. Does that complete your business, Ms. Gross?
Judge, I believe it does as far as my hearings. I have several documents I need to prepare and get to the court, so I'll just stick around maybe with my camera off, and that way if y'all need anything, I'll still be here.
That's fine. Who do we have next?
And also, Your Honor, if the state can just notify the court, I do have Miss Elena Hernandez from the state from my office assisting. I did provide her with some cases. However, now the state is ready, if the court is ready on Nathaniel Collins, and I'm not sure if that was waived or if we were going to go forward. Whether or not he wanted Lister and Hope to represent him, I do see that he has no attorney at this time. I'm not sure if Lister and Hope made an announcement, whether or not, or if the court made an announcement whether or not he was appointed.
I think Mr. Lynch, was that your case?
I actually spoke to Mr. Collins, Your Honor.
Okay.
He did want us to represent him, but he wanted to waive his preliminary hearing. So
Okay.
I will get a waiver to you shortly.
Okay, thank you.
Thank you. And may the witnesses on that case, Your Honor, Nathaniel Collins, be excused.
Yes. Is it Thomas LaRodney? Or LaRodney Thomas Will? As the officer, as state's witness?
Officer LaRodney Williams as well, if they could be excused, Your Honor.
Okay. Those witnesses may be excused. I don't see any of them on, but the witnesses in that case, they may be excused. All right, so what's the next case?
Your Honor, the state is ready to proceed with Bills. I believe the officer is actually present under Natalie's iPhone, but if I can just confirm that information. I believe the officer first name is Natalie. I'm just not sure if that's
okay. And what was the case? What was the case name?
The case, I have Treyvion Bills. And that is, Your Honor, that is position.
I see. That looks like Mr. Lynch's case.
That's correct, Your Honor.
Are you prepared, ready to go forward, Mr. Lynch?
I am prepared. If I could just have one moment to make sure. Yes, I'm prepared.
Okay. And I see it says Natalie's iPhone. That's The officer that I have listed is Ramon Sanchez, but I'm assuming.
Yes, Your Honor. I believe that Officer Sanchez was actually the training officer and the second officer on scene, if I'm not mistaken.
Okay. So Mr. Lynch, just let me know when you're ready and then we'll call this case.
Your Honor, I am ready to proceed. Thank you very much.
Okay. This is going to be case number 2021 WA18963. Mr. Bills is charged with 1 count of battery. Ms. Ponder, you may swear your witness in and begin your examination.
Officer, will you please raise your right hand? Do you swear or affirm that
Hold on 1 second. Officer Sanchez, are you gonna provide testimony from Officer Sanchez?
Yes, sure. If I need to, Your Honor, I can swear in both officers.
Well, if he was going to testify, I was going to place him in the waiting room. But if he was a training officer and he's just going to observe and not testify, then that's.
I don't believe I would need Officer Sanchez to testify at this time for this particular hearing. So if he could just, since he was the training officer at the time, if he could just wait and observe, that's fine. But I don't believe I would need his testimony for this particular hearing at this time.
Okay, that's fine by me.
Thank you, Your Honor. Officer, may you please raise your right hand, please? Do you swear or affirm that the testimony that you're about to give in the state versus Treyvion Bills is the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
And may you please state your first and last name for the record, please?
Natalie Aztec.
And Officer Aztec, how are you currently employed?
Sir.
I'm sorry, you were breaking up. How are you currently employed?
Uniform police officer, Clayton County Police Department.
And how long have you been employed with the Clayton County Police Department?
Approximately 10 months.
And being employed with the Clayton County Police Department, does it require you to be post-certified?
Yes.
And being post-certified, does that give you arrest powers?
Yes, ma'am.
And on this particular incident date, November the 5th, 2021, were you in fact post-certified?
Yes, ma'am.
Were you employed in the capacity as an officer with Clayton County Police Department?
Yes, ma'am.
Now I want to bring your attention to, did you respond to an incident location 5919 Trammell Road, Morrow, Georgia?
Yes, ma'am.
And is that located here in Clayton County, Georgia?
Yes, ma'am.
And why did you respond to this particular incident location?
Darren Jemison had called in regards to a domestic disturbance to the residents.
Okay, and when you arrived on scene, upon your arrival, who did you make contact with when you arrived on scene?
First contact was Darren Jemison. He was outside the residence.
Okay, and Darren Jemison, who was he later identified as?
As the brother to Treyvion Bills.
And who was Treyvion Bills later identified as during the course of your investigation?
Jemison advised that that was his brother and he was allowing him to stay at the residence where he lived.
And when you arrived on scene, did you make any observations?
Darren had large swelling to his right cheek and he was spitting blood and he had a scratch on his left arm.
And so did, and when you say Darren, is that Mr. Jemison?
Yes, ma'am.
Okay. And when you spoke with Mr. Jemison, did he inform officers how he retrieved those particular injuries?
Yes, ma'am. He had stated that his brother had punched him in the face and scratched his arm.
And with this information, did you make physical contact with the brother, Mr. Treyvion Bills?
We did.
Okay, and you were able to make a positive identification of Mr. Bills while on scene?
Yes, ma'am.
And with this information, would you be able to identify Mr. Bills today in court with an article of clothing or a physical description?
Yes, ma'am. He's wearing an orange suit with a white mask.
Okay, let the record reflect that the witness has identified the defendant Treyvion Bills. And during your course of investigation, after gathering this information from Mr. Jemison, did you speak with Mr. Bills?
Yes, ma'am.
And what did Mr. Bills inform you?
That Jemison attempted to get into his face and with a verbal altercation, and he stated he never punched his brother, he just pushed him back.
So with that information, did you determine who was the primary aggressor in this incident?
Yes, ma'am.
And who did you determine was the primary aggressor?
Mr. Treyvion.
And at that point, did you make a lawful arrest with Mr. Bills?
Yes, ma'am.
And what ultimately did you charge Mr. Bill with?
Battery, family violence.
And why did you charge Mr. Bills with battery, family violence?
They lived together and he had substantial swelling to his cheek as well as spitting blood.
And you were able to see the actual physical swelling on Mr. Jemison, is that correct?
Yes, ma'am.
No further questions from this witness, Your Honor.
Mr. Lynch?
Yes, officer, when you arrived on the scene, it was you and Officer Sanchez, or were there also other officers present?
Other officers present, sir.
Do you remember the names of the other officers who were present?
Not at this time, sir.
Okay. At this time, were you wearing a department issued body cam?
Yes, sir.
Do you know whether or not your body cam picked up your investigation?
Yes, sir.
Okay, so you have had a chance to review the body cam and you know that it recorded the incident?
Yes, sir.
Okay. And the first person you spoke to was Duran, is that correct?
Yes, sir.
And other than Duran, were there any other witnesses that were interviewed or that were in the area?
Just Duran and his brother, sir, Treyvion.
Okay. And you had a conversation with Duran, and he said that there was an argument having to do with Treyvion living in the residence. Is that correct?
Yes, sir.
And you also spoke to Treyvion Bills. Is that correct?
Yes, sir.
And you yourself interviewed him, or was it one of the other officers?
Multiple officers, sir.
Okay. And Mr. Bills told you that his brother was intoxicated, correct?
He advised that he was drinking alcoholic beverages. Yes, sir.
Did you or any of the other officers evaluate Mr. Duran for manifestations of intoxication?
No, sir.
So just completely ignored that or didn't think it was relevant?
I can't stop him from drinking in his own home, sir.
That's true. However, it may be relevant to the confrontation. Is that not correct?
Yes, sir.
Did you smell alcohol on Mr. Duran?
No, sir.
Okay. Were there manifestations of intoxication that were apparent?
No, sir. His brother advised that he was drinking alcoholic beverages. I didn't observe him drinking any alcohol, and I did not smell anything on him as well.
His demeanor, he didn't appear to be intoxicated?
He was shaken. He said he was just nervous.
And did he appear to be under the influence of any other narcotics?
No, sir.
Was that okay? Were there any discussions between you and the other officers about whether Mr. Duran may have been intoxicated?
I don't recall, sir.
Okay. Now, Mr. Duran told you about the physical altercation. Did he say, did he make any statements about what the first physical contact was?
No, sir.
So he didn't elaborate as to who made physical contact with the other person first.
Oh, he'd stated, yes, sir, yes. So he had stated that he was trying to have a conversation with his brother about getting a job in regards to him living there. And he had stated that his brother punched him in the face at that point. I'm sorry, I got confused by the question.
Sorry. So he said that basically the argument escalated to force when my client punched him in the face and there was no physical confrontation before that. Is that the
Correct.
accurate statement? Okay. And you talked to Mr. Treyvion Bills, who denied that he punched his brother in the face and told you that he had only pushed him away. Is that correct?
Yes, sir.
And the injury that you observed to Mr. Duran, you said that it was his cheek was swollen.
Yes, sir. His right cheek.
Were any photographs taken, or was that documented, body cam or otherwise?
Body cam, sir.
No, no actual photographs taken other than what was captured on the body cam?
Correct.
And you said that, well, were there any other injuries that were observed?
His right cheek was very swollen. The inside of his mouth had a fresh cut in it, and his left arm had a scratch on it.
And did you inquire about how the scratch on the left arm had occurred?
Yes, sir. He stated that it was due to his brother.
What did you find out?
That his brother did it in the midst of, he was unknown exactly when.
So he said, I don't know how I got this scratch, but my brother must have done it.
Not in those words exactly.
Was there any mention of him falling to the ground at any time during this altercation?
No, sir. He'd stated right after he had ran out of the house and contacted the police.
Okay. No further questions.
Any follow-up, Ms. Ponder?
Follow up from this witness, Your Honor.
May this officer be excused?
Yes. The state has no other witnesses at this time, Your Honor, and the state rests.
Okay, ma'am, you are free to go. Thank you for appearing today. Do we have any argument?
Yes, Your Honor.
Judge, at this time, I would leave.
Hold on. So the state gets to open and close if they so desire. If they want to waive opening, then
I apologize.
Start,
I apologize.
Mr. Lynch.
Absolutely.
Ms. Ponder, what's your desire?
The state desires, Your Honor, to just waive and reserve.
Okay, Mr. Lynch.
Your Honor, as to the probable cause determination for battery family violence, the defense would note that there's no additional witnesses and that, there's conflicting testimony about, who the initial aggressor was or whether or not a punch was delivered or merely defensive actions. The determination that Mr. Treyvion was the initial or the primary aggressor was made solely on the basis of Mr. Treyvion, who, while I understand hearsay is certainly admissible at a preliminary hearing, the probative value of hearsay is still of a low quality as far as evidence is concerned. But with that, Your Honor, I would just, I would rest.
Ms. Ponder?
Yeah, you heard testimony from the officer in this incident. Just want to highlight, Your Honor, that the officer did testify that the defendant did admit to pushing his brother. The state will argue that that's the first point of physical contact in which the defendant actually admitted to pushing his brother. Whether or not there was an argument did not result in him placing hands on the victim in this case. Officers did observe physical injuries. They observed the brother, he had bleeding. Also, the officer testified that there was visible swelling. And also, regard to family violence, both the defendant, although they are brothers, and that doesn't constitute family violence, they were actually living together at the time of this incident. So the state will argue, Your Honor, that there is enough evidence in order for this case to be bound over to state court.
Okay, I'm going to find that the evidence was sufficient from the testimony provided to bind this case over to state court. So I'm going to bind over this one count of battery to the state court of Clayton County. Is there anything else?
Not from the state, Your Honor.
Okay.
No, Your Honor, thank you.
You're welcome. Mr. Bills can be returned. What's the next case? With Mr. The first case on the calendar, Mr. Balderas Laura. I just noticed that the person that was the state's witness is Officer Laxon, who, of course, recently lost his life. Was the state intending to go forward with a different witness?
That is correct, Your Honor. I did speak with Miss Gross about this incident while we were in the breakout room. Due to the nature of the sensitivity of the topic, we didn't want to go into full detail, but the state believes that there was, based on CAT report, that there was an additional witness. However, we were unable to have that witness or review CAT report at this time. And so that's the reason the state had consented to the an OR.
Okay.
And I'm
Okay.
preparing that now, Your Honor. I should have it to you shortly.
Okay.
And Your Honor, while we're at it, I did have one more announcement that I had missed, and that was on Mr. Browning. He's the one that was added from yesterday.
Yes, ma'am.
I did speak with him, and he did want for us to represent him. He did have public defender's office with the felony charge. And, you know, I spoke with him about the fact that we're not going to be able to actually have his hearing today due to them not having the witness. So he wanted to request if we could just briefly speak with the court about possibly reducing his bond whenever the court has a minute, since we can't do his hearing today. He has been in custody, I believe from what he said, for about a month and a half.
Okay. We will reach him last. I'll make a note because I don't have information about his case.
Your Honor, the state will argue that the state does not have any information on his case as well. Also, as the court indicated earlier, that he is entitled, they're entitled to a bond because of the misdemeanor. However, he does have a bond in this case. It is my understanding that Ms. Gross is wanting to have a hearing for bond modification or to reduce bond. The state will ask for the court to continue his case. If we are addressing bond in order to prepare and make sure that we have any necessary information and not just look at the case and not be able to prepare an argument or any necessary witness we need for this bond modification.
I understand, and I would add that I believe under the victim rights statute, that the state would have to notify the victim, the alleged victim, of the hearing, and give that person an opportunity to be heard. So we'll discuss it, but I don't believe that I would be able to go forward on that today, Ms. Gross, without violating that statute.
I understand, Your Honor. If I can just have a chance to speak with him at the end so I can let him know.
Yes, ma'am. Let's see. So there is I think I signed an appointment order as it relates to Jamal Clayton. Was that is going to be a hearing, or?
Judge, I believe what I submitted was a bind over order. I think it's the one, but now that you mentioned that, I don't know if there was a special bind over I was supposed to use in this situation. He's the individual that refused to come out,
Right.
and refused to meet with me and refused to come to court. I did send over an order for you to bind the case over, but if I need to submit an additional order that explains why, I can do that as well.
No, you don't, Mr. Lynch. Just after a certain point, as a judge, you reach where everything starts to kind of fold in on itself. And so I try to make notes and hold on to things so that I could make sure that I'm doing the right thing. So I will trust your representation as it relates to Mr. Clayton. Mr. Collins was waiver. Michelle Covington was accused. What are we going to do with Mr. Essien-Umoh, Mr. Lynch?
So, Judge, that was the case where I had stated that it appears that there's a felony matter and a misdemeanor matter. I'm certainly prepared to go
forward on the misdemeanors.
I am prepared to go forward on the misdemeanors. I did explain to him that I could not represent him so long as, in regards to the felony matter, which appears to be being treated as a separate incident. I can't. I'm looking at the charges. I don't have the warrant, the WAA in front of me, but it would appear if you were arrested for loitering or prowling, possession of marijuana less than an ounce, or use of possession of drug-related objects, and then you were brought into the jail and they charged you with a felony or crossing guard lines. I don't understand how those are separate cases or separate issues. And Your Honor, I would tend to agree. However, I don't have the, it's not up to me, how the state chooses to proceed. And I'm not going to speak to what I think the facts are. This is just, I think that what may have happened is that the drug-related object it was part and parcel to the crossing the guard line with drugs. That's not, that is just my take on it, not from any client conversation or anything.
No, that's fine. I honestly, I don't know how the DA's office will get around double jeopardy as it relates to this. If they see the charges and they send it back and choose not to pursue the misdemeanor charge and your client pleads day one to the charges, they've already passed on it, even though the felony couldn't be prosecuted even though the felony could not be prosecuted in state court. if the felony prosecutor passes on all of these charges that are misdemeanors and they're related, I don't see how they can come back and prosecute it on the back end. But hey, I don't know.
Well, can't speak to that. All I can say is that if we're going forward, I can only go forward on the misdemeanors. I'm prepared to do so, and I would leave it at the discretion of the court as how to best proceed given this situation.
And Ms. Hernandez, is that a case that you're going to deal with?
Yeah, I'm sorry to interrupt you. I'm familiar with that particular case and those charges.
So, Officer Riley, I'm assuming the only way you get charged with crossing the guard line is when you're brought in and you're searched, and then contraband or alleged contraband is found. And so I understand how necessarily the arresting officer wouldn't be the person that drew up the felony charge. But I'm still, and maybe I'm just getting old now and I can't see it, but my understanding is that like matters are treated and prosecuted in the same fashion, and even charges where it appears as though they're not like matters can be combined for the purpose of prosecution or for taking a plea. But that's not my dog. That's not my fight. So Officer Riley, you would be here testifying as it relates to the crossing the drug lines charge. Is that correct?
No, sir, the laundering.
Okay. So I have it looks like it says Treyvion Bills.
Yes, sir, that was the deputy that actually searched him once he crossed the guard line.
Okay. And for the two misdemeanors, it just lists the state of Georgia as the witness. So you're here to testify as it relates to the possession of marijuana less than an ounce and the loitering or prowling?
Yes, sir.
Okay. Are we prepared to go forward with Mr. Essien-Umoh's case?
Defense is ready, Your Honor.
Okay. Are you handling that case also, Ms. Ponder?
I am, Your Honor.
Oh, Ms. Hernandez. Okay. Give me 2 minutes to get a glass of water, and we'll get started on that case. Let's bring up Mr. Essien-Umoh.
So who's next? Who you looking for?
Are you sure about that? You gonna be good?
Okay, I'm back.
Do they have to bring the inmate up?
Yes, they're bringing him up.
What inmate you looking for, sir?
Mr. Richard Essien-Umoh, Essien-Umoh.
Yes, sir.
What's the last name?
And so just that I'm clear, the use or possession of drug-related objects is a misdemeanor charge, but it has Mr. Kraft from the public defender's office listed as a lawyer. So is that charge going to be prosecuted in Superior Court or State Court?
From what I can see from the police report, I'm guessing it's would be prosecutor here in state court.
Okay. So this is how this gets confusing. The officer that's listed for the use of possession of drug-related objects charge is the same officer that's listed for the felony charge.
Judge, I'm not going to try to speak to what the facts are, only what they may be. Our office received an application with loitering and prowling and BGCSA. And when I looked it up in the system, it looks to me as though the drug-related object charge would be going with, under maybe a theory that it is was part of what was discovered during the crossing of the guard line. I think, again, that's not based off of any discussions or any knowledge of the facts. It would appear that way just based on the application for defense and how it's listed in court case inquiry. Although if I can.
No, and I understand the position that you're in. I'm not asking you to step over any line at all. I'm just trying to figure out what it is that I'm supposed to be hearing. Officer Riley, you were not involved in the use or possession of drug-related object charge. Is that correct?
No, sir. I was just standing there when it all was discovered.
Okay. Okay. So again, this is why this stuff shouldn't get parceled out, because it just leads, in my opinion, too much confusion. I posed the hypothetical that me and a co-defendant decide we're going to rob a bank, and we steal a car so that we'll have the ability to rob the bank. We go rob the bank, and then we commit several misdemeanor traffic violations while we're leaving the scene from robbing the bank. Theoretically, the state can try to parcel everything out. Say, well, the stealing the car was different than the robbing of the bank, and the running from the scene or fleeing from the scene was separate from stealing the car and robbing the bank. So we're going to try you on the stealing the car charge first. If we don't get a conviction, we're going to try you on convicting or robbing the bank second. If we don't get a charge, we're going to try you on the misdemeanors. And I just don't believe that is supported by the theories under double jeopardy. So I just believe that at some point this is going to get called out, and I don't know what's going to happen. I mean, if I was the state, I would put it all together, let the defense argue that it should be separated. Then you're not dealing with jeopardy issues. But I digress. So we're going to deal with State of Georgia versus Richard Essien-Umoh, who's charged in warrant number 2021 WA18788 with possession of marijuana less than an ounce, and warrant number 2021 WA18789 with loitering or prowling. Ms. Hernandez, please swear in your witness, and you can begin with your presentation.
Yes, Your Honor. The state at this time would call Officer Bowe or Officer Riley. Sorry.
Riley.
Okay, sorry, I didn't see you. Okay, Officer Riley, if you can please raise your right hand so I can swear you in. All right. Do you swear that the testimony that you shall give on this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and put your hand down.
And before we proceed, Ms. Hernandez, I see that Officer Bowe is here. Do you intend to call Officer Bowe as a witness?
I may,
On these two charges?
I may.
Okay. Officer Bowe, I'm going to place you in the waiting room as it relates to the rule of sequestration. And if you are needed, you'll be brought back out as a witness.
And Judge, I didn't mean to interrupt. And obviously the state can call whatever witnesses they want for whatever purpose. I would just like to put on the record that, I'm here to represent Mr. Essien-Umoh on the misdemeanor charges. Any testimony about what may be a felony charges puts me in a position where I would just ask the state to be cognizant of that I cannot represent him as to his felony charges, and that those are not before the court at this time. And
so, Mr. Lynch, the only two charges that I'm considering at this point is possession of marijuana less than an ounce and the loitering or prowling. The crossing the guard line with drugs or gun or alcohol charge, and the use or possession of drug-related objects charge. It shows that your client is being represented by the public defender's office on those two offenses.
Okay. Thank you, Judge.
You're welcome. I'm sorry, ma'am. I cut you off. Go ahead, Ms. Hernandez.
All right. Officer Riley, please state your name for the court.
Officer Terrence Riley.
And how are you employed?
I'm employed with the City of Lovejoy Police Department.
And how long have you been employed by Lovejoy Police Department?
I've been with Lovejoy since August of this year.
And are you post certified?
Yes, ma'am.
And that means that you have arrest powers?
Correct.
Were you on duty on November 1st, 2021?
Yes, ma'am.
And do you recall being dispatched to 11465 Terra Boulevard in Hampton? It's a Walmart?
Yes.
And is that here in Clayton County?
Yes, ma'am.
And when you arrived to the Walmart, who did you encounter?
I encountered one of the undercover loss prevention officers.
Okay. And what did the loss prevention officer tell you?
He basically advised me about 10 minutes before closing. The defendant came inside of the store and was just walking around. And at the time that the store closed, when they approached him and asked him if he needed help, he began to become irate with them. And when he did that, they just backed away from him and called the police at that point.
And when you arrived there, did you see the defendant?
I didn't see him right away, no, ma'am.
Okay, but you made contact with him later?
Made contact with him later, yes.
Okay, and could you please identify the defendant based on an article of clothing or hairstyle?
Yes. He's right there, the face mask on and jumpsuit.
Let the record reflect that the officer has identified the defendant. And when you came in contact with the defendant, did he make any statements to you?
The first initial attempt that me and a coworker made, we were unable to locate him. The loss prevention and other employees say that he's still inside the store. He has not left out because they was watching the exits and stuff. So we continued to search again, and we went to the automotive department where they keep the tires at. And I was able to locate him sitting on the floor on top of some tires, eating a bag of chips, drinking the soda, and watching TV on his phone.
Okay, and once you made that initial contact with the defendant, did he make any statements to you?
He immediately jumped up and said, "What you want? What you want?" while he was like backpedaling for me.
And around what time, if you recall, around what time did this incident occur?
Walmart closes at 11 o'clock, so it was probably by that time, maybe 11:20, around that time.
And at that time, was the defendant placed under arrest?
When he started backpedaling, and at that point he was detained and escorted outside of the store, pending further investigation and stuff. Speaking with him and doing a search of him, that's when everything was discovered with the marijuana.
Okay, so what was discovered?
Marijuana, well, what's expected to be marijuana, which was a green leafy substance that he had in his pocket.
Okay. Nothing, nothing further at this time, Your Honor, for Officer Riley.
Mr. Lynch.
Officer Riley, what time did you initially arrive at the Walmart?
I believe it had to be right at 11 o'clock. Right, they were closed when I got there.
Okay. And from speaking to Walmart employees, you found out that they closed at 11 o'clock, right?
Correct.
And so what time did you, I guess, receive a call or information that there was a person, in the store that they wanted, checked out or investigated? The
initial call came probably right before they initially closed, about 3 or 4 minutes before they closed. I'm not sure on the exact time.
So they called before the store had closed, and you spoke to some associates who said that they approached him and asked him if he needed any help, correct?
Correct.
And they said that he kind of became irate, so they backed off, right?
Yes.
They didn't tell you that they had communicated to him that the store was closed, did they?
They didn't advise me of that, no.
So you had no reason to believe that at that point, Mr. Essien-Umoh was aware that the store had closed, right?
No, sir.
Okay. And you said initially when you made contact with him, he backpedaled from you and kind of said, what do you want, right?
Correct.
And you detained him inside Walmart at that point, correct?
Yes.
And then you took him outside of the store, right?
Yes.
Did he cooperate with you when you walked him outside of the store?
Yes, at that point he was in handcuffs, so he had no other choice for the most part. Okay,
so he had no choice but to cooperate with you, and you had detained him for what reason?
Based upon how he jumped up and took an aggressive stance for his safety as well as mine, he was detained.
You said he took an aggressive stance. When you put him in handcuffs, he didn't physically resist you, did he?
He refused to turn around, so myself and my coworker had to turn him around to place the handcuffs on him at that point.
And you had conversations with him outside of the Walmart, right?
Yes.
And in these conversations, did he tell you that he wasn't aware that it was closed?
He never mentioned it. He said he went inside there because he was homeless and he had nowhere else to go.
Okay, but so there was no determination about whether he realized at the time that the Walmart was closed, right?
He mentioned to me that he knew the Walmart was closed because he wanted to apologize to them for putting him through that.
What he said, he knew the Walmart was closed at that, at the initial point, but you testified earlier that, the initial call came in before the Walmart was closed, right?
The call came in right before they closed, yes.
And you also testified that that you had no information that the fact that it had been closed, that it was closing at that time, was communicated to Mr. Essien-Umoh by the staff there due to him being irate. Is that correct?
From my understanding, staff, when they approached him, they was approaching him to advise him of all of that. And that's where he became irate with them. So they just backed off from him.
Okay. Was your investigation captured on a body cam?
Yes, I believe. Yes, sir.
Okay. And when you took him outside of the Walmart, you searched him, correct?
Correct.
And you said you discovered the marijuana. Where did you say you discovered the marijuana?
It was in his pocket.
And why were you reaching into his pocket?
Because that's where he said his ID was at.
Okay. He never gave you consent to search, correct?
It was a search incident to arrest, correct.
So he was under arrest at that point?
At that point, he was for the laundering.
Did you ask Mr. Essien-Umoh to explain? Well, he explained that you asked an explanation about why he was in Walmart, right?
Correct.
And from that investigation, were you able to determine when he found out that the Walmart was closed?
No, I was not able to determine that, no.
Okay. I apologize if I already asked this, but you said your investigation was captured on body cam, correct?
Yes.
Okay. Now, there was some mention about him eating chips and drinking a soda. There was no allegation or evidence that those items were stolen from Walmart. Is that correct?
No, sir. The defendant frequents a convenience store across the street from that location where he said that's where he purchased the things at. We did ask an associate, it was these items based some of the things that they sell within their store, and the associate said no.
Okay. So then it was very clear that those items weren't stolen from Walmart, right?
Correct.
There was also no information about him attempting to steal anything or do anything of that nature, correct?
The associates, they couldn't tell because after they backed away from him, they could not see him from that point on. They didn't know where he went at inside of the store.
Okay. And just to reiterate, the initial call came in either before closing time or right around the time when Walmart closed, right?
Yes.
And you never determined if Mr. Essien-Umoh had any knowledge prior to being approached of what time the Walmart actually closed. Is that correct?
Other than him stating he knew it was closed, no.
He knew it was closed by the time that you got involved with him, correct?
Correct.
Okay. No further questions.
Ms. Hernandez, any follow-up?
Yes, just very briefly. Officer Riley, you, just to be clear, when you encountered the defendant, what was he doing?
He was sitting on the floor, sitting on top of some tires, like a sofa almost, watching TV on his phone and eating his chips and drinking his soda.
And also when you arrived at the location, that was when Walmart was already closed to the public?
Yes.
Okay, So was there a lot of people inside of the store?
The only people that was inside that store at that point was associates.
Okay. And the associates had tried to make contact with with the defendant.
Yes, it was undercover loss prevention officer that attempted to make contact with him.
But they were they unsuccessful?
When they made contact with him, that's when he became aggressive towards them.
Nothing further, Your Honor. Thank you.
Any recross, Mr. Lynch?
No, Your Honor.
May Officer Riley be excused?
Yes, Your Honor, and for this case, the state would rest.
Okay. May Officer Rowe be excused?
Yes, Your Honor. That's for that other incident, so it's
Yeah,
fine.
let me bring him back in. Or I said Rowe. Officer Bowe, it appears your testimony is not going to be necessary, sir. You're free to leave at any point. So, any argument?
The state would reserve the time to go last.
Okay.
Close.
Mr. Lynch?
Judge, loitering and prowling requires that an individual be at a place in a time or manner not usual for law-abiding individuals under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. I expect the state to rely on the characterization of Mr. Essien-Umoh as being aggressive towards the associates when they approached him. And certainly that is for your consideration. However, the record as presented to this court would show that at that time, there, at least according to the officer's testimony, it had not been clearly communicated to Mr. Essien-Umoh that in fact the Walmart was closed at that point. So at that point, I would argue that it's not unusual for a law-abiding citizen to, not lose track of time, especially when it's so close to the closing time. Now, they made a decision to back off due to his demeanor. The exact demeanor or what was said to be aggressive, that was not in testimony and is not before this court, but you can ascertain that they made a decision not to engage with him further. Now, so at that point, the record doesn't show that he had any knowledge that the Walmart was indeed closed. There's no dispute that he hadn't stolen the items that he was consuming or that he had engaged in any behavior that alerted or would raise concern for the property inside Walmart. Now they characterized him as being aggressive, but there's no mention of any threats or any indication that he was a threat to those people. And he did have conversations with the officer. As far as the loitering and prowling charge, Judge, I would argue that, once he, was detained by the officer, he was cooperative at that point. And so as far as the loitering and prowling, would argue that probable cause had not been established because the record would reflect, doesn't show that he knew that the Walmart was closed at that point or did anything that would, justify a reasonable person in the fear for their safety or the safety of any property. The record reflects that, he didn't know it was closed and it just went from there. So I would ask the court not to bind over the loitering charge.
Ms. Hernandez?
Yes, Your Honor. Officer Riley did testify that upon walking inside of the Walmart, the defendant, I'm sorry, I can't pronounce his name. The defendant was sitting on tires, eating chips and looking, at the phone after the time, once the store had closed. And Officer Riley also testified that those chips and the soda were not products that were carried by the Walmart, after confirming that with the Walmart employees. Also, the Walmart employees did try to approach the defendant. However, he became aggressive towards them. And he also became aggressive towards Officer Riley when he began to backpedal once Officer Riley attempted to make contact with him. Officer also stated that, it was later on in the evening, and that, there wasn't people in the store, and that the only people in the store were the employees. And as far as the marijuana charge that was found subsequent to the arrest, it was described what was possible marijuana is described as a green leafy substance. And then the defendant was in custody at that time. Nothing further, Your Honor.
Okay. I think this does present a close case. I had to actually pull the statute out and read it just to be certain, but I do believe, based upon testimony that was provided, that there is sufficient evidence to bind these charges over loitering and prowling and possession of marijuana less than an ounce. The testimony about the Walmart associates at least feeling enough concern that they call law enforcement to come, and then the testimony that he wanted to apologize about not to the store about not being there beyond the closing time, and also the testimony about essentially bringing in chips and soda to come in and eat at the store. It does not show to me or present to me to be a customer comes in at 5 minutes to closing and customers there after closing, but customers there shopping, trying to purchase items. So I'm going to find that it's sufficient to bind over. I understand your argument, Mr. Lynch, and that may be successful at the next stage of this case, but I'm going to bind the two charges over to state court. Okay, what's the next case that we have?
Judge, I know I have remaining Grover, Ms. Hart, and Eric Hinton. I'm not sure which cases my colleagues have, but I'm prepared to go forward. Of course, if the state has another one that would be more, that they're more ready on, I don't have any issue with that either.
Okay, I'm ready to go with whatever case that comes up. Mr. Glaze, you have any announcements?
I'm sorry, Your Honor. I believe my internet connection went out, but I do have hearings on Poole and Wells that are ready to go when the state is ready.
Okay. I'm ready on either case. Like I said, if I can just start calling them in alphabetical order, or if I hear no objections, I'll just go in alphabetical order.
If I may, for Rain Hart, the state would be asking for a continuance. The officer is not present at this time.
And Judge, I would object to a continuance just based on the officer not being present. Ms. Hart, I believe, has been incarcerated on this for a significant period of time. And, you know, absent some sort of compelling reason why the officer is not here to establish probable cause, which is the burden of the state to present enough evidence for probable cause in order for her detention to be lawful. And so, you know, I would object to it being continued just because the officer, for whatever reason, is not present.
Ms. Hernandez, what's your response?
1 second, Your Honor.
Does anybody have the date that Ms. Hart appeared for first appearance?
I can get that, Your Honor.
I can double check. I do know that she has been in custody since 11/5. A little bit over a month.
Looks like I did the first appearance on Ms. Hart.
And the first appearance was on 11/5, Your Honor.
Yes.
And the bond was set at 1,500.
For each count. Is this the officer that was in training?
I'm gonna double check that information.
Your Honor, this is not the case where the officer was in technical training.
Okay.
I don't believe that the court made a decision on that particular case, but this is a different case.
The
That was-
case where the officer was in training, what's that person's name?
That case, Your Honor, is Stern. Last name is Stern. The officer is in technical training. He advised of this training on December the 8th.
Right.
And I know that the court was going to address this matter later on in the calendar.
Yes. Okay. Ms. Hernandez, Ms. Hart is charged with disorderly conduct and criminal trespass. It's another one of these airport cases. Mr. Lynch,
Yes, Your Honor.
did you
Excuse me.
I'm sorry, go ahead.
No, I didn't mean to interrupt you, Your Honor. I was just going to say that I have spoken to Ms. Hart and I am familiar with the police report.
Looking at this, is there maybe a belief that Ms. Hart is suffering from some form of mental illness?
I certainly couldn't rule out that she's suffering from mental illness. However, based on our conversations, I do believe that she is competent to proceed.
No, I know the statute makes it seem clear, but it's a wide
Sure.
gulf between competence as the court defines it and ability to proceed.
Sure. And without revealing too much, Judge, it certainly is possible that she has mental health issues. However, I don't know what, or even if she does. She is able to talk rationally about, what she's been charged with, explain her position, whether or not mental health played a role. I think it's certainly a distinct possibility. However, I have been able to speak to her. I believe she understands, pretty well, what a probable cause hearing is,
Right.
and what the accusation is. So that's all I can really say as to that, Your Honor.
Ms. Hernandez, I'm going to ask you a question that in all fairness, you do not have to answer. Okay. But this is something I'm looking at, the warrantless arrest affidavit and the allegations contained in there. She was arrested on November 4th. So she's been in custody for approximately 40 days. Would your office, and I don't have her criminal history before me that I'm looking at now, would your office sentence her to 40 days in custody under these charges?
Your Honor, that is something that I can't give an answer to.
Okay, that's fine. That's fine. That's
Okay.
fine. I'm not trying to, put you in a trap, but this is a situation where in my opinion, continuing this case would be just adding time on to her punishment in jail. Now, I am required to follow law just like everybody else. If you can tell me a reason that this case should be continued for the availability of this officer on these charges, I'm happy to hear it.
Yes, Your Honor. Just given the nature of the charges, she was out banging on, or just given the facts of the case.
I'm sorry, Mr. Lynch, did you have an objection?
Well, I certainly would object to the court considering a recitation of the facts by the state. The state is not a witness in the case. I understand they have a police report, but I'm not suggesting that the state can't argue, but I would ask Your Honor not to consider anything that doesn't qualify as competent evidence as to.
I believe the state can proffer what they believe that they can show.
Okay, I apologize.
No problem. Go ahead, Ms. Hernandez.
Okay, so just given the facts of the case, I'm not going to get into them. The state would just have a concern and given her credit for time served or releasing her on a bond or at this time, just due to the nature. I'm not sure if she has somewhere to go, if she has a facility that can take her in, if there has to be I'm not sure if there even has to be like a mental health eval. She was, I believe that Officer Tillman would come on here and, testify as to her behavior towards him and towards other people at the location. And just given all that information, Your Honor, the state would ask for a continuance on the case.
Judge, I would object to that. The state doesn't have any information to my knowledge about what her mental status is, and I don't think it's relevant. I believe I can state from my place that she understands what she's charged with. She can't make bond. She's being held without bond, and now the state, doesn't have an exact reason why there's no officer here to address that. So there's not even going to be an ability for her case to be bound over. Whether she needs a mental health eval, I do not believe is relevant. The pretrial detention is not supposed to be punitive. And there, it has always been, recently there was legislation passed, I think, that said that, the court should make an inquiry into a person's ability to make bond. Well, she can't make bond. She's held on a misdemeanor charge. I understand the allegations are concerning that she used inappropriate language. However, there's not really anything beyond that. And so the state is essentially asking for her to be more detention prior to a probable cause determination, which she's already waited, I believe, approximately 45 days or, over 30 days in order for a court to make that determination. And so I would object to it being continued for that reason. And I would ask that the court dismiss this case for lack of prosecution.
So let me tell the two of you where I am now as it relates to this case. I do not believe that I'm leaning towards dismissing this case for want of prosecution. I need to understand why the officer isn't here. These charges, Ms. Hernandez, if I dismiss the case right now, you can get on your computer and type up an accusation and accuse it 30 minutes from now, and charges are moving forward. She's just in custody. I mean, she's not in custody. I always have a concern, Mr. Lynch, when I see these issues that sort of, in my mind, create possibly a red flag. I don't want your client getting out of jail today and going back in custody tomorrow on new charges. It's just not helping anybody. So that was the purpose of the inquiry that I was making as it relates to possibly her mental health, because if she's has an issue and she's non-compliant with either medication or counseling, she's gonna be in custody on new charges.
And Judge, without revealing anything, I said there is a possibility that some mental health issues may have played a role. This is not the case of a chronically homeless, acutely mentally ill person who has no ability to conduct themselves in the world, based on my conversation with Ms. Hart. She may have some struggles. She may have some issues with mental health that are certainly, and I'm not saying she does or she doesn't, but if she does, certainly, there would be something that would be a justifiable concern to the court, and I understand that. However, I don't think that while this case happened at the airport, where many of these such cases do, I do think that this is a little different. I don't want to. I just complained about the state getting into the facts, and if that was
No. We're just talking here.
But
because let me just let you know, Mr. Lynch, whether she has a mental health issue or not, it will not prevent me from dismissing this case for the officer not being present. Ms. Hernandez, do you have any information as to why this officer is not present?
No, Your Honor, I don't have a reason as to why he is not present today.
Okay. All right. So if I don't hear a reason why this officer is not present that satisfies me, this case is going to be dismissed, but I'm going to hold on that announcement until we're done. So, Mr. Lynch, please, I made a note, but please make certain that we revisit this issue as we move on.
Absolutely, Your Honor. And may I just request, so I don't forget, that in the event that it is dismissed, if I could have a brief chance to just meet with her, explain to her what's going on, and make sure I have the ability to contact her should the state go forward in another fashion.
That's fine. That's fine. All right. So let me see. Are we going to go forward with Mr. Groover?
Yes, Your Honor, I'm ready to go forward with Mr. Groover.
Ms. Hernandez, are you going to handle that also?
That'll be me, Your Honor.
Okay. Can we bring up Mr. David Gene Groover Jr.? And it looks like the state's witness is Officer Reed. Okay, Mr. Groover, I need to tell you this is going to be your preliminary hearing today. My name is Brad Gardner. I'm going to be the judge presiding over this hearing. This hearing is not private, so please don't say or make any statements you wouldn't want the whole world to hear. Do you understand that, sir?
Sir.
Okay. Ms. Ponder? Let's bring
Yes,
up
Your Honor, I'm
Officer
present.
Reed is here. You can swear in Officer Reed and you can begin your presentation.
Thank you, Your Honor. Officer, may you please raise your right hand, please? Do you swear or affirm that the testimony that you're about to give in the state versus David Groover is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, you can place your hand for me. Officer Reed, may you please state your first and last name for the record, please?
Tyler Reed,
Okay, and how are you currently employed?
full-time employee with the Clayton County Police Department, Uniform Division.
And how long have you been employed with the Clayton County Police Department?
Next month makes 2 years.
And being employed with the Clayton County Police Department, does it require you to be post-certified?
Yes, ma'am.
And being post-certified, does that give you arrest powers?
Yes, ma'am.
Okay, and I want to bring your attention to November the 1st, 2021. On this particular date, were you in fact post-certified?
Yes, ma'am.
And you were in the area of I-75 North and Terra Boulevard, is that correct?
Yes, ma'am.
And is that located here in Clayton County, Georgia?
Yes, ma'am.
Okay. And what on this particular date in this particular area, what did you observe?
I observed Mr. Groover standing in the middle of I-75 North entrance ramp near Terra Boulevard. He appeared to be confused, and once I approached him, he started walking from the northbound side to the southbound side. So I stopped him because he was walking towards live traffic, and I approached him and asked him, why are you standing in the middle of the road? And he advised that he needed help. So I asked him, what type of help do you need? He said, I need an ambulance. So I asked, okay, why do you need an ambulance? He stated, I just need an ambulance. I'm like, I'm clear. I have to tell my dispatch why you need an ambulance. Why do you need to call an ambulance for you? So he ignores the question. He advised that how far is the ambulance? How far is the hospital? I said, if you walk, depending on how fast you walk, 10 to 15 minutes. But why do you need the hospital? I just need help. So I asked him, does he have any ID on him? He advised no. So he started digging around in his pockets while he's walking backwards towards the live I-75 South ramp. And I advised him take his hands out of his pockets. He advised no. So I went to grab Mr. Groover to bring him back towards me, to bring him away from traffic. He lunged away from me. At this point, I asked him again, do you have identification, and please take your hands out your pockets? He advised, no, I'm not doing anything wrong. I'm not doing anything wrong. I'm like, you're standing in the middle of the I-75 South ramp. It's called pedestrian roadway, and that is a crime. So at this time, he advised, well, I just want help. And he keeps walking towards the I-75 South exit ramp. So I pulled him towards me. He lunged away. At this time now, he's obstructing me from doing my investigation. So I advised him that he's detained. Once I grabbed him to detain him, that's when he pulled away from me to try to prevent me from detaining him. So I guided him to the ground in the middle of the I-75 South ramp. And we began tussling for me to gain control to put him in cuffs. And that's when two EMT workers saw me tussling with him, and tried to help me gain control of the situation, which he still refused to cooperate and to put his hands behind his back. So at that point, after asking him several times, he was tased to gain compliance, which is when he allowed me to place him into custody.
Okay. And so I just want to make sure that the particular area that you observed, Mr. Groover, in this particular area, it's your testimony that this was in fact in the roadway?
Yes.
So it wasn't on a sidewalk?
No, he was standing in the left lane on the live I-75 North ramp going towards Tire Boulevard.
And so were you able to, of course, make an identification of this particular individual?
Yes, once I was actually heading towards a call on Upper Riverdale for Mr. Groover, where he was trespassing on a property, and they called us to come remove him because he was scaring customers away. Prior to me getting to that actual incident location on Upper Riverdale Road, he was standing on I-75 North in the left lane in the middle of traffic.
Okay. And how were you able to identify this individual as David Groover?
The notes from the call stated that it was a white male wearing a black and white jumpsuit, and he matched the description from the call.
Okay. And so I know that he indicated that he didn't have any form of identification. So after you made this arrest, how were you able to identify that in fact this person was David Groover?
I actually wasn't able to identify him until we got to the jail because he refused to identify himself to me, my sergeant, or the Clayton County Fire Department. So he had to get fingerprinted, and then that's when a couple of inmates at the jail recognized him because he just bonded out for a drug charge. So they recognized him and realized that once he came back, that's how he normally acts when he's under the influence of drugs.
Okay. And so through the fingerprint system, you were able to identify the defendant as David Groover?
Yes, because he refused to tell me who he was and tell my sergeant.
And just for the record, if I was to ask if you were able to identify that individual today, for today's hearing, would you be able to identify that individual with an article of clothing or a physical description?
Yes, ma'am. He's wearing a white mask and a white jumpsuit.
Let the record reflect that the witness has identified David Groover as the individual. And ultimately, what did you charge Mr. Groover with?
He was charged for pedestrian in the roadway, for refusal to remove himself out of the roadway, and for obstruction for not providing me his name and date of birth and not allowing me to place him into custody.
Okay. No further questions from this witness, Your Honor.
Mr. Lynch.
Officer Reed,
Yes, sir.
do you know whether or not your investigation was captured on a department issued body cam?
It was.
Okay. And at the time you made contact with Mr. Groover, were you the only officer out with him, or were there other officers with you?
I was by myself.
Okay. And you said this happened at near the I-75 ramp at Tara Boulevard?
Yes, he was on I-75 South, I-75 North.
And just, you know, there's a traffic intersection there, correct, at that area?
Yes.
And at that traffic intersection, there's a crosswalk, correct?
I'm not sure.
You're not sure. So you don't know whether there is an area near the traffic light where pedestrians are allowed to cross, you know, when they have the right of way?
Yes, I'm sure there is, but I don't recall exactly where in that area where he was. I know he was past the intersection, past the crosswalk, and he was on the actual I-75 North ramp.
Approximately how far onto the ramp, though, would you say he was?
A couple feet.
Just a couple feet away from the crosswalk?
Yes, he was, I would say, approximately maybe 3 to 5 feet away from the crosswalk. He was clearly on the I-75 North ramp.
And so when you first made contact with him, you said basically you were asking him, you know, what he was doing at that point?
Yes, I asked him how come he's standing in the middle of the entrance ramp.
And he made statements that he needed help?
Yes, he advised that he needed help.
And you wrote a report, correct?
Yes.
And in that report, do you remember if you stated whether or not you had ruled out that he was having a mental health or some other sort of episode?
Yes, I believe he was either having a mental episode or he was on narcotics or some type of drugs due to his pupils and the way he was acting. He was acting very jittery.
I'm sorry, one moment. I'm trying to pull up your report. Do you have your report with you?
Yes, I do.
Okay. You wrote in your report, the subject was able to answer all my questions in a clear and timely manner, so I ruled out the suspect having a mental episode, correct?
Yes.
So is it that you ruled out he had a mental episode, or is it, as you just testified before this court, that you thought he was having a mental health episode or narcotic?
Yes, as I said it before, I thought he was either having a mental episode or that he was under the influence of some type of drug. And due to the fact that he was able to answer my questions clearly, I decided to rule out that I believe that he was under the influence of a type of drug.
Okay. And so you basically, did you tell the suspect that you were gonna help him to get help of some form?
I asked the subject, why did he require me to call an ambulance? And he didn't answer my question. He just kept stating he needed help. And I advised him I have to notify my dispatch why I'm calling an ambulance. I can't just call an ambulance. So why do you need an ambulance? He just kept saying, I need help.
And so at some point after you weren't able to ask for help based on the information he was able to provide you, he started walking away from you. Is that correct?
He started backpedaling towards the I-75 South ramp where cars were actively speeding down, entering Terra Boulevard.
Is he walking like either against traffic or with traffic, or is he?
He was walking with his
across?
back towards traffic as cars were coming southbound onto Terra Boulevard. He was unaware of the vehicles approaching him from behind.
And so, okay, so he was walking, and I apologize, I just want to make sure I understand where he is. You're saying he's walking away from the intersection towards the, was it the off ramp or the on ramp that he's
When
walking?
I first approached him, he was on the entrance ramp from I-75 North. And then as I'm talking to him, he's walking between the grassy area from I-75 North to the 75 South side. But he's walking backwards, making direct eye contact with me. So as I'm continuously trying to do my investigation and talk to him, he's backpedaling towards live traffic.
Okay, but so essentially, when you first saw him, he was just crossing the ramp, right?
No, he was standing in the middle of the road, shuffling back and forth.
And you said that was about a couple feet from the walkway or the traffic intersection.
Yes, he wasn't in the intersection. He was not standing in a crosswalk. He was standing in the middle of I-75 North ramp.
And can you tell me again what time you, at what point you decided to go hands-on with Mr. Grover?
After asking him for his ID and he told me no, and he kept shuffling his hands in and out of his pockets, I decided to grab him to detain him for a pedestrian roadway because he kept backpedaling towards traffic. And that's when he advised that I was not going to place him into custody, even though I advised him I was detaining him.
And when you said he told you no as to whether he would identify himself, did he tell you no, or did he just tell you that he didn't have ID on?
He said no. I said, do you have an ID on you? He said no.
And so based on that, that's when you decided that you had enough to detain him, correct?
Yes, for a pedestrian roadway, because he's still in an active roadway and he's refusing to take his hands out of his pockets. And he stated to me he doesn't have ID. So I'm not going to allow him to continuously stay in the middle of the roadway if I felt as if he was under the influence of the drug, for his safety and my safety, so we both don't get hit by a vehicle.
Understood. He walked away from you though. He didn't like run away from you or anything like that.
No, I was still within the arm's reach of him. He was just backpedaling slowly as I'm talking to him.
Okay. Did you use your department issued taser?
Yes, that's after I guided him to the ground and asked him several times to put his hands behind his back, in which he told me no. And that's after 3 more individuals came over to help me detain him, and he still refused to put his hands behind his back. So before I tased him, I warned him, I'm going to tase you, do not comply. And he still advised no, so he was tased for compliance.
Okay, and that's after he'd already been, the struggle had progressed to a point
Yes.
where it was on the ground.
Yes, he was on the ground for about 2 minutes before he was even tased, because I gave him orders over and over to prevent him from being tased, and he still told us no, which is all on body cam.
No further questions at this time.
Any redirect?
I just have one question for the officer. Officer Reed, are you in fact a medical professional?
No.
No further questions from this witness, Your Honor.
Mr. Lynch, any recross?
No.
May this officer be excused.
Yes, Your Honor, this officer can be excused.
Thank you, Officer Reed. Sir, you are free to go.
Thank you.
Any argument?
The state has no further witnesses, Your Honor.
Okay.
At this time, state rests. They also
Okay.
waives and reserves closing.
Okay. Mr. Lynch?
Judge, I'll leave it at the probable cause determination at the discretion of the court at this time.
Okay. I don't believe sufficient evidence has been presented for this case to get
I
found
don't believe the
over.
state made an argument.
Oh, I'm sorry, ma'am.
Regarding this particular case, Your Honor, it appears that Officer Reed did testify that Mr. Gruber was in the roadway. He received calls in which indicated that a white male was actually in the roadway. He made contact with Mr. Gruber while he was in the roadway. Officer Reed did testify that it was on I-75 South. I did ask if he was on the sidewalk, in which the officer indicated he was not. He was clearly in the roadway. As the court is aware, officers, when officers ask for identifications, individuals to present some identifications. At that point, it appears that Mr. Gruber was actually obstructing officers, in which he refused to give some form of identification. Officer Reed did indicate that he still did not know Mr. Gruber's name until he actually had to go into custody at the jail. For that, Your Honor, the state will argue that there is sufficient evidence and probable cause to bound this over to state court.
Your Honor, may I just briefly respond to the point about identification?
Your Honor, it's my understanding that Mr. Lynch indicated that he would like for the court to consider if there's any closing arguments. I believe that Mr. Lynch had his opportunity to make any closing argument.
That's correct, Ms. Ponder. The concern I have with this case is you have a person asking for help. When police arrive, the person is, from the testimony of the officers, person is asking for help. And I don't know how we've gotten to this point in our society where somebody's asking for help and the help they get is get taken to jail.
Your Honor, I would, the state would argue that although Mr. Gruber was asking for help based on the officer's testimony, the officer still has a duty to know exactly who he is helping. And so the officer testified that he wanted to know Mr. Gruber's name. At that point, he didn't know anything about Mr. Gruber or any past incidents, but he was asking for any type of identification so that he can, during his investigation, even if he was to assist Mr. Gruber with some form of help while he is in the middle of the street, he is to still identify the individual for officer safety, for other people's safety in the community as well, to know exactly who is that he is trying to help at that moment.
And I'm not laying this at Officer Reed's feet. Officer Reed did what I would want any law enforcement officer to do, is to try to ascertain what's going on. I think this is a situation where I have not, and one day I'll get an understanding, but it just seems like the 1013 and the whole thing of involuntary commitment for people, that involuntary commitment is placing them in a jail, not taking them to a hospital where they can get help. And I just don't believe that fits within this scenario. If you're talking about whether Mr. Groover knowingly, intelligently, and voluntarily violated the law, the officer's testimony about him being in a confused state and stating that he needs help, I think, cuts heavily against that. Mr. Lynch, I allowed Ms. Ponder to add to her argument. I'll allow you to add to your argument, and Ms. Ponder, I'll give you an opportunity to respond.
Thank you, Judge. As far as the obstruction, she mentioned obstruction, refusal to identify oneself. That is, refusal to identify is only obstruction at the point that the officer has reasonable suspicion that a crime has been committed. So just refusal to identify cannot be obstruction unless that officer has reasonable suspicion that a crime has been committed. And as you pointed out, the evidence shows that when he made contact with Mr. Grover, it was more of an indication that he was having some sort of, an episode. And while he may not be qualified to make a medical determination, he did have Mr. Grover asking him for help. And he also did testify that he was, within a few feet from the crosswalk. So I'm not sure that the state even laid out probable cause for, the pedestrian in the roadway offense. And even if the officer, did have some sort of reasonable suspicion, the officer still has to act lawfully with regards to the escalation of force. But if he didn't have reasonable suspicion to stop him for anything, then Mr. Grover is free to walk away from the officer. So whether or not he's having, having a medical issue is not a crime. And so I would just argue that the probable cause hadn't been laid out. It hadn't been established that he had reasonable suspicion to detain him for a crime. Therefore, refusal to identify in that scenario is not obstruction under the laws of the state.
Ms. Ponder?
Your Honor, the state will argue once again, as the officer indicated, he is not a medical professional. There is nothing in evidence to support there's any type of mental health concern. There was nothing that was offered from either the state or the defense, whether or not Mr. Groover actually has any mental health concerns. There is nothing in evidence to support that argument. That is merely just an assumption based on either officer testimony or what defense counsel could argue or assume at the time. However, the officer Reed did indicate that he received calls of a pedestrian in the roadway. That is a crime. Officer Reed indicated that that was a crime for Mr. Groover, to be in the roadway, and that he proceeded to question him or ask for identification because he was violating the law while being in the roadway, which is a crime in which he refused to do so. for whatever reason, there's no evidence to support that. However, it did hinder his investigation. When he attempted to make a lawful arrest, there was some struggle. And while officer was trying to make a lawful arrest after his investigation, Mr. Groover still did not provide no identification, and that was only determined through a fingerprint system at the jail. The information that Officer Reed retrieved while he was at the jail, he did not have that information of knowing any type of mental health concern and or any type of drug history usage until he got to the actual jail. So the state will argue that although there is some assumptions made whether or not Mr. Groover has any type of mental health concerns, there is no evidence to support that, considering Mr. Officer Reed, in fact, testified that he is no medical professional. With that argument, Your Honor, the state will argue that there is probable cause and enough evidence for this case to be bound over to state court.
Okay. Having heard the argument of counsel and the evidence presented during this hearing, I'm going to dismiss these two charges. The basis for my dismissal was that the testimony of the officer that he arrived on scene after receiving calls of person in roadway, and when he encountered Mr. Groover, through the officer's own testimony, Mr. Groover kept saying he needed help. Now, I don't know anything beyond that, but I just don't believe that a person who encounters an officer and is asking for help, that encounter somehow gets converted into a criminal act or meets the mens rea element as it relates to Mr. Groover. So, Mr. Lynch, I'm going to need you to submit an order for this case to be dismissed, and I'll sign it. Make sure you provide a copy to Ms. Ponder when you email it.
Absolutely, Your Honor.
Okay. Next case I have is Hinton.
Your Honor, I also represent Mr. Hinton, and I'm ready to proceed whenever the court is ready for that.
I'm ready to proceed on that.
The state is ready, Your Honor.
Okay. For the jail, this is Eric Daniel Hinton, Hinton.
Okay, sir, he's on the way. Yes, sir.
Mr. Hinton, sir, this is your preliminary hearing. My name is Brad Gardner. I'm going to be the judge presiding over this hearing. I need to admonish you that this hearing is not private. It is public. Anything you say can be used against you. So please do not discuss your case. For the record, this is the state of Georgia versus Eric Daniel Hinton, charged warrant number 2021 CW 54951 with committing the offense of battery in the second degree, which is normally a felony. Second time. And it looks as though originally this case was sent to the public defender's office, but I guess it's been sent back down to state court. Is that correct, Ms. Hernandez?
Yes, Your Honor, from what I'm able to see.
Okay. And do you have your officer here?
Yes, Officer Robinson.
I see Robinson on my form also, but I don't see an Officer Robinson. We had Officer Robinson I'm sorry, the days are, it was either earlier today or it was yesterday. So have you checked to make certain that Officer
Yeah.
Robinson is here?
He's logging back in. He was on here. That's why I was like, what happened?
Okay.
Have an announcement. Sorry, I don't want to interrupt anything that may be going on.
No, ma'am.
Okay, Mr. Browning, we're just going to leave. We're just going to take the continuance, put him on the next calendar. And if he changes his mind and wants to waive, he'll call me.
Okay.
And Your Honor, I believe that is all that I have. If I can be excused, Mr. Lynch and Mr. Glaze will remain and handle everything else.
Yes, ma'am. Have a good day.
Thank you, you too.
You're welcome.
Your Honor, this is the jail.
Yes, ma'am.
Is there some inmates that can go back?
I believe so. Mr. Browning, Mr. Bald, there was Mr. Balderas Laura, BALDERASLARA.
Okay.
Mr. Bernardine.
Okay.
Sorry, to make a note. Mr. Treyvion Bills.
Yes, sir.
And I said Mr. Browning before. Mr. Clayton.
Didn't show up.
Mr. Nathaniel Collins. Miss Covington. Mr. Essien-Umoh, ESSIENUMOH.
Yes, sir.
Mr. Fair. Mr.
It should be a second.
Garcia.
Yes, sir.
Mr. Groover.
Yes, sir.
Mr. Hadley. HADLEY. Need to hold on to Miss Hart.
Yes, sir.
Rain Hart. We're about to have the hearing for Mr. Hinton. Mr. Jefferson.
Yes, sir.
Mr. McRae.
Yes, sir.
Mr. Mejia Nunez.
First name is Victor.
Yes, ma'am.
Yes, sir.
Believe sign an order appointing Mr. Ripa to Lister and Holt. Mr. Glaze.
Yes, Your Honor.
As it relates to Mr. Ripa, what was the announcement?
So I have drafted an appointment order. I'll send that over shortly. My announcement, Your Honor, based off of my conversation with him and the conversation he had with the court, is that would be a judicial bind over. Based
Okay.
off of the things that he said, I wouldn't feel comfortable having him waive that on his own or go forward with the hearing.
Okay. So Mr. Ripa can go back.
Yes, sir.
Mr. Stern, hold on to Mr. Stern. That's going to be a decision I'm going to make at the end of the hearing.
Yes, sir.
And Akira Wimberly can go back.
Yes, sir.
Okay.
Okay, so the only ones that we should still have up here is Stern, Hinton, and Hart.
Poole and Wells also, they're going to be here.
Yes, sir. Okay.
So it should be 4.
Yes, sir.
Okay.
Yes, thank you,
So
sir.
you're welcome. Bring up Mr. Hinton so we can start his hearing. We have Officer Robinson here now.
Jones, would you first give me a 2-4-4-4 and 2-4-4?
Hinton.
It's right here.
Hart, is the female.
Ready, sir?
Thank you, Mr. Hinton, sir. This is your preliminary hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm going to be presiding over this hearing today. I need to caution you that nothing that you say here is private or privileged. So please don't discuss your case or say anything you wouldn't want the whole world to know. You understand that, sir?
Yes, sir.
Ms. Hernandez, you can swear in your witness and present your case.
All right, Officer Robinson, if you can please raise your right hand. Do you swear that the testimony that you shall give on this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
You can go ahead and put your hand down, sir. Thank you. Please state your name for the court.
Officer Robinson.
And how are you employed?
Say that again.
How are you employed?
I am employed with the Clayton County Police Department.
And how long have you been employed by the Clayton County Police Department?
8 years.
And are you post-certified? And do you have arrest powers?
Do I have what?
Arrest powers?
I do.
Were you on duty on October 12th, 2021?
Yes.
Do you recall being dispatched to a domestic disturbance off of 5891 Riverdale Road?
5890 Riverdale Road, yes.
Is that here in Clayton County?
Yes.
When you arrived to the location, who did you come in contact with?
Brittany Hurst.
And did you ask her why, what had happened?
Yes.
Okay, and what was her response?
She stated that she and her live-in boyfriend, Eric Hinton, had a verbal dispute which turned physical. She stated that she then asked the Eric Hinton to leave while they were arguing. She finally asked him to leave. She stated that he started gathering items, and while gathering those items, with a closed fist, he punched her on the left side of her face.
And were you able to see any injuries to Ms. Hurst?
I saw swelling on her left cheek.
And at that time, did you come in contact with anyone else?
I did not.
Did what was the relationship between Ms. Hurst and the defendant?
Her boyfriend, girlfriend. And they live together.
Nothing further at this time, Your Honor.
Mr. Lynch?
Yes, Officer Robinson.
Yes.
Just a few questions for you. When you arrived to this scene, were you the only officer out, or were there other officers with you?
There was another officer with me.
Do you remember which officer that was at this time?
I don't. When we go to a domestic, 2 officers at minimum will go. But once we do the report, we just put our name in it.
Understood. Do you know whether your investigation was, I'm sorry, did I talk over you? My internet might be messing up.
If we're the primary officer, then we'll just put our name in the report.
Okay, understood. Thank you. Do you know whether or not your investigation was captured on body cam?
Yes, it was.
Okay. And the only 2 individuals that you questioned during your investigation would have been Mr. Hinton and Ms. Hurst, correct?
No, I didn't question Mr. Hinton. He was not on scene.
I apologize. So the only person you spoke to was Ms. Hurst, right?
Correct.
And you stated that she said that basically she told Mr. Hinton to leave and that there was an argument about that, right?
There was an argument during that time, yes.
And she said that at some point while he was gathering his things, she said that he got up and punched her in the face. Is that accurate?
He stated while gathering items with a closed fist, he did punch her, yes.
Okay. Did you ask Ms. Hurst to write a statement?
I did.
Did you review the statement before you made your decision about whether to take out warrants?
Yes.
Okay. And in that statement, she wrote, she wrote a statement saying that he pushed her outside. Is that correct?
Yes.
And did you say that you observed injuries on Ms. Hurst?
I did.
Were those documented in any way?
I did not take pictures. I just went by what I saw. It should have been on the body camera.
And what were those injuries that you observed?
It was swelling on her left cheek.
Now, did she describe her taking any actions, physical actions against my client, Mr. Hinton?
No.
Okay. So there was no discussion about her potentially being charged with an offense?
No, not during that incident, no.
Okay. But on previous incidents, there had been?
Well, I mean, we dealt with them again shortly after that. I'm not sure, about a month or so after that, we dealt with them again.
Thank you. No further questions at this time.
Ms. Hernandez, any redirect?
Yes, just very briefly. Based on the information that Ms. Hurst gave you, is that how you were able to obtain the warrants?
Yes.
Okay. Nothing further, Your Honor.
Any recross, Mr. Lynch?
No.
May this officer be excused?
Yes, Your Honor, and the state would arrest.
Officer Robinson, thank you, sir. You're free to go. Have a good day.
Thank you.
Any argument?
The state would reserve just the closing.
Okay.
Judge, I would just point out that the arrest decision or the decision to take out a warrant was made solely on the testimony of and statements of Ms. Hurst. She's not here to testify in court. I understand hearsay is admissible, but its probative value is low. So I'll just ask the court to take that in consideration when making the probable cause determination.
Ms. Hernandez?
Yes, Your Honor. Officer Robinson stated that Miss Hurst had lived with her boyfriend, the defendant here, Mr. Hinton, and based on that information, he was able to take out the warrants for the defendant. Furthermore, Mr. Hinton was at the scene. He left, so there's no way the officer could have gotten his statement. Also, the officer was able to see a visible swelling on Ms. Hurst's left cheek, and she described to him that the defendant punched her with a closed fist on the left side of her face, which would match the visible injury. Nothing further, Your Honor.
Okay, thank you. I'm going to find that there's sufficient evidence to bind this case over to state court. The testimony of the officer, the outcry of the alleged victim, and the officer stated he saw injuries to her face consistent with the outcry, I believe is sufficient to bind this over. So this will be bound over to the state court of Clayton County. Mr. Hinton, sir, you're free to go back. The next case I have is Poole.
I'll be right back.
Yes, sir. Anybody else?
Frederick Poole, Poole.
Yes, sir.
Mr. Lynch, is that your last case?
Your Honor, I believe it's my last case.
You're waiting for my decision as it relates to Ms. Hart?
Yes, Your Honor, and I think I have a few more documents I need to send to you. I will be on standby until such time as you make that decision.
Okay.
Your Honor, if I may, before we continue with the matter for Mr. Poole, Officer Tillman is now online, so the state would be ready to move forward with Ms. Hart.
Okay, great. We'll circle back, Officer Tillman, to Ms. Hart's case next.
Okay, sir.
So we'll deal with Mr. Poole, and then we'll come. I think they pulled Mr. Poole off the camera. We're going to do Mr. Poole next, and then, now, and then do Ms. Hart next at the jail.
Mr. Poole, come on.
Thank you.
Yes, sir. Yes, sir.
Mr. Poole, this is your preliminary hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm the judge that will be presiding over this hearing. I want to advise you that anything you say during this hearing is not private or privileged, so please don't say anything about your case or discuss anything you wouldn't want the whole world to know. Ms. Hernandez, are you going to be conducting this hearing?
Yes, Your Honor.
Okay, you can swear your officer in and begin your presentation.
Yes. The state would call Officer Simmons. Okay, Officer.
And give me 1 second, I'm sorry. Just for the record, this is State of Georgia versus Frederick Poole, charged in warrant number 2021 WA19493 with committing the offense of simple battery. I'm sorry. Go ahead, Ms. Hernandez.
All right, officer, if you can please raise your right hand so I can swear you in. Okay, do you swear that the testimony that you should give on this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and put your hand down. Thank you. Can you please state your name for the court?
Name's Officer Brittany Simmons.
And how are you currently employed?
I'm a police officer for Forest Park Police Department.
And how long have you been employed by Forest Park Police Department?
16 months.
And were you on duty on November 15th, 2021?
Yes.
And do you recall responding to the area of Elaine Drive and Stony Brook Road?
Yes.
Is that here in Clayton County?
Yes.
When you were in that area, who did you encounter?
I searched the area to see if I could find a domestic and a male in a red truck. I didn't get his name because he left. Stated that they were at 4465 Berkshire Road. So I went over to the street over and I was approached by Mr. Poole.
And are you able to identify Mr. Poole?
I am.
Okay, can you please describe what he's wearing or hairstyle?
Orange jumpsuit, white mask.
Let the record reflect that the witness has identified the defendant, Mr. Frederick Poole. Once you encountered Mr. Poole, did you have an interaction with anyone else?
Yes. Her name was Kayla Adrian.
And as part of your investigation to this incident, did you speak to Ms. Adrian?
I did.
Okay, and what did she tell you had occurred?
She told me that Mr. Poole had come to the area of Theater Park where she was with some friends and grabbed her by the back of her hoodie and walked her back over to his residence.
And how did Mr. Poole grab her by the hoodie?
He stated that he snatched the back of her hoodie with a tight grip and escorted her back.
So did you also speak with Mr. Poole as part of your investigation?
I did.
Okay, and what did he tell you?
Mr. Poole stated that Kayla had allegedly stolen a wallet from him. He stated that he went to confront her at Theater Park, and when he found her, he grabbed her by the hoodie, the back of her hoodie, and took her back to his house, his residence.
And did you ask Miss Adrian about the wallet?
I did.
And what did she tell you?
She stated that she did not steal his wallet. She grabbed the coat to put on and walk to the park. Upon returning to the residence, when she searched the coat pockets, there was a wallet inside and it was returned.
Nothing further at this time, Your Honor.
Mr. Glaze?
Hi, Officer Simmons. So my name is Joel Glaze, and I just have a few questions for you. So you said that Miss Adrian said that the wallet was in the coat. Is that correct?
Correct.
Okay. And Mr. Poole told you that the reason he confronted Miss Adrian was because he believed that she had stolen his wallet.
Correct.
Okay. And so that was his reason for grabbing the hood, as you understand it, is because she had his wallet in the jacket.
Correct.
Okay. And would you say whether or not Miss Adrian intended to steal the wallet, it would be reasonable for Mr. Poole to assume that maybe she had stolen the wallet.
No,
You wouldn't. So if she grabs a coat and it has a wallet in it and he's aware that the wallet's in there, it's not reasonable for him to assume that maybe she did steal it.
no. He can't say that that she necessarily stole the wallet.
Correct. He may not be able to prove that she stole the wallet, but is it reasonable for him to assume that she might have stolen the wallet, that she knew the wallet was in there?
If she knew so.
Okay. All right. No further questions, Your Honor.
Any redirect?
Yes, Your Honor, just very briefly, one question. Officer Simmons, do you recall what part of the hoodie Mr. Poole grabbed onto?
The actual hood that makes it tight, he grabbed the back of the hood of the hoodie.
Okay, nothing further, Your Honor.
Any recross, Mr. Glaze?
No, Your Honor.
Okay, may this officer be excused?
Yes, Your Honor, and the state would rest.
Okay. Thank you, Officer Simmons. You're free to go. Have a good day.
All right.
Any argument
Yes, Your Honor. I do have argument for the defense.
for the state?
Yeah, just closing, Your Honor.
Okay. Go ahead, Mr. Glaze.
Your Honor, I would argue on behalf of Mr. Poole that there's no probable cause for battery here. While he did allegedly grab the hoodie under 16-3-24 in the Georgia Code, he does have a legal right to use a reasonable force in stopping a trespass of his property. The evidence that came out in this hearing is that the wallet belonged to Mr. Poole. Miss Adrian did have that wallet. While we cannot prove that Miss Adrian stole the wallet, it is reasonable for Mr. Poole to believe that the wallet was stolen. And so therefore, he does have a legal right to use reasonable force. I would argue that it was reasonable to obtain his wallet back by grabbing her by the hood. Your Honor, he didn't use any punches or he didn't push her or anything like that. So we would maintain that because he does have that legal right under OCGA 16-3-24, there's no probable cause for battery.
Ms. Hernandez?
Yes, Your Honor. Officer Simmons testified that Ms. Adrian had grabbed the jacket or the hoodie that she was wearing and that Mr. Poole's wallet was inside of that hoodie, that Ms. Adrian was unaware that the wallet was inside of the hoodie, and that once she found out, once Ms. Adrian found the wallet, she gave it back to Mr. Poole. Officer Simmons also testified that Mr. Poole grabbed the hoodie by the hood really tightly on Miss Adrian, and Mr. Poole was the one that was arrested for simple battery. Nothing further, Your Honor.
Okay. I'm going to find that there is sufficient evidence to bind this case over to State Court of Clayton County under the simple battery charge is what I have here. And my findings based upon the testimony that Mr. Poole grabbed the alleged victim and pulled her back. Now, his purpose and reasoning for grabbing her, that's something I think a jury may need to consider, but at this stage, I think the evidence is sufficient to send this over to state court so that a jury can make that determination. Mr. Poole, you're free to go back. Let's bring up Miss Hart, and then we'll go back to you, Mr. Glaze, for Mr. Wells.
Your Honor, if I could make an announcement, I'm not sure will inquire whether or not the court was inclined to continue Mr. Stern's case. I was kind of a bit of confused. I know we had many cases that a few cases that we asked to continue. I know one being that it was dismissed because there was no information whether or not, or it was going to be dismissed, whether or not there was any information regarding the officer. However, the state did receive information regarding the officer, Mr. Stern's case. So I wasn't sure if the court wanted to address that now, or was it in fact continue at the call of the calendar?
It was not continuing at the call of the calendar. That I did not. Is that your case, Mr. Lynch? I did not write down.
I believe that was Ms. Gross' case, but I could be wrong.
I believe that's accurate. It was not. Okay. You're referring to Stern, right?
Yes.
Yes, that was.
I had Stern, Your Honor.
Oh, okay. Mr. Glaze, did you hear Ms. Ponder's argument?
And I can
Your
provide
Honor,
if the court will want, the court wanted the information in defense counsel.
if Ms. Ponder could restate that information, that would be great.
Yes, Your Honor. So at the call of the calendar, the state did inform the court, the state did ask for the court to continue Mr. Stern's case because the officer was unavailable due to technical training during the course of recess, and also being able to further investigate on what exactly is technical training. I know that the court had questions, and so I kind of wanted to get some more insight on exactly what it is. I did speak to the officer. He was able to give me a call back after I sent a text to the officer. He did inform me that this training was mandated, is for post-certification. He needed for accreditation. He did indicate that he was scheduled for this training since September of this year. He has been in training since last Monday, which was December the 6th, 2021. He is scheduled to be in training until December the 17th, this Friday, 2021. He did indicate that he informed our office. Our investigative assistant, Mr. Reggie Evans, did reach out to officers to notify them of today's hearing on last Wednesday. I did receive an email. I was forwarded an email from Mr. Evans in which Officer Feliciano did actually give us that information on last Wednesday when we notified him of today's hearing. He did inform me that it's called technical TFO. It's for him to receive his hours he needed for accreditation. He cannot miss those hours, or he would not have enough hours in order to be post-certified, is my understanding. And it was continued due to COVID restrictions. And so they had to split up different type of classes, is my understanding. And so that's the reason for the state asking for this case to be continued.
Mr. Glaze.
Your Honor, I had objected earlier just because my client has been in custody for close to a month now. Your Honor, I'll just leave that to the court's discretion. I understand the necessity of the officer's training, so I'll just leave that to the court's discretion.
Yeah, as I was thinking about this, I was inclined to grant the state's request. This officer needs to go through training. Because of the extended period of time, as with COVID, I am concerned about people sitting in jail and their cases not moving. I was looking over, there will not be a calendar next week for misdemeanor cases. The earliest that this case could be heard is December 28th, which is another, 14 days from now. Ms. Ponder, were you able to determine whether the officer would be available on the 28th? I know that was not information that was in your purview at the time.
I did speak with the officer, and I apologize. I did speak with him to ask whether or not he will in fact be available during this month if it was continued on a Tuesday. I wasn't sure exactly when it will be continued. I just know that misdemeanor preliminary hearings are on Tuesdays. He did in fact instruct me that once training is over on Friday, he will be available. It's my understanding. I just didn't know exactly what date this case will be continued to.
Well, it looks like Judge Case Johnson is going to be doing the preliminary hearings during the week of the 27th. I don't, my concern with the straight dismissal of this case is the allegations. So I'm inclined to grant the state's request for a continuance, and I'm going to try to get this case placed on the December 28th calendar.
Thank you, Rainer.
Just hopefully in the future, if this comes up where an officer is going to be, is not going to be able to make it to the hearing, it's better to have these things kind of known as early as possible so that accommodations can be made. Obviously, Mr. Stern is still in custody, and these are misdemeanor charges. But being that there's the charge.
The 28th, and that's fine.
Okay, thank you, Ms. Wesley. The fact that these are charges that involves an alleged victim, I don't want to just dismiss this case and without hearing more and knowing more and understanding more. So that this case is going to be State of Georgia versus Wayne. Stern is going to get continued to December 28th at 8:30 in the morning. So for the jail, Mr. Stern can be sent back. All right, we're ready for Ms. Hart. Where did the jail go? Oh, there you go. Ms. Hart, ma'am, this is your first appearance here before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm the judge that's going to be presiding over this hearing. I need to caution you that this hearing is not private or confidential, and anything you say can be used against you. So please don't discuss the facts of your case. Ms. Hernandez, this is going to be your case? Okay.
Yes, Your Honor.
Would you please swear in your witness, and then we can get started.
Okay, the state would call Officer Tillman.
Yes, I'm here.
Can you please raise your right hand so I can swear you in? Do you swear that the testimony that you should give on this matter today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can go ahead and put your hand down, sir. All right. And can you state your name for the court?
Officer Leroy Tillman,
And how are you employed?
City of Atlanta.
And how long have you been employed by the Atlanta Police Department?
26 years.
And are you post-certified?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
Were you on duty on November 4th, 2021?
Yes, ma'am.
Do you recall responding. Do you recall an incident that happened at the N1 outer door of Hartsville-Jackson Airport?
Yes, ma'am.
And is that in Clayton County?
Yes, ma'am.
And when you arrived to the N1 door, can you describe what you saw?
I was inside of the precinct and there was loud banging on the door. At the same time, a dispatch call came out of a female outside of N1 screaming profanities at passengers. At that time, I went out the door. Just in front of N1, walking past the N1 door toward the N2 door was Miss Rain screaming profanities. I walked up, I said, ma'am, are you okay? What's going on? She said, leave me alone, MFer, FU, ho, ASS, ho, just screaming profanities. And at that time, by the N1 door, the American baggage carousel was full of passengers. So I'm walking behind her, asking her, can she please stop using profanity and swearing? And she wouldn't. And it was at that time I asked her to come to the precinct. She wouldn't. At that time, myself and 2 other officers got her in custody and walked her to the precinct.
And do you see Ms. Hart today on your screen?
Yes, ma'am.
And can you describe what she's wearing?
Blue jumpsuit with the white mask on.
Let the record reflect that the witness has identified the defendant, Ms. Rain Hart. At that time, why was Ms. Hart placed under arrest?
Because she was screaming profanities in the airport and there were families and children present.
And did Ms. Hart have any luggage with her?
I believe she had a bag with her. Like, I think it was a book bag, some type of bag.
Okay. Did at any point did she say she was gonna board a plane?
No, ma'am.
Did she say she was coming back from a flight?
No, ma'am.
She just had a book bag?
I believe it was a book bag or some type of tote bag. I believe she had some type of bag.
No further questions at this time, Your Honor.
Mr. Lynch?
Yes. So did you learn so that she was banging on the door of the police precinct, right?
Witnesses stated she was donkey kicking the door. She was standing with her back to the door, kicking it with her foot.
Did you ever learn why she was trying to make contact with the police officers?
No, sir.
There was never any complaint about a cell phone being stolen?
No, sir.
Was your investigation captured on body cam?
Yes, sir.
And you said that she was next to a baggage carousel where there were passengers?
Yes, sir.
Or patrons of the airport and people in that area?
Yes, sir.
And how close was she to that area when she was allegedly making these profane outcries?
How close was she to the carousel?
Yeah.
Oh, 5 feet, less than that. It's right by the back door of the precinct.
And did you said that, well, did you actually observe any children or minors, or are you just assuming that they were there?
Oh, no, absolutely. Yes, I observed children, teenagers, men, women. It was packed. It was full.
Okay. No further questions.
Any redirect?
Yes, just very briefly. When you Officer Tillman, when you encountered Ms. Hart, how was her demeanor?
Very belligerent, very loud. Just belligerent and really loud. Almost like she might have been drunk or something.
No further questions at this time, Your Honor.
Any recross?
No.
May this officer be excused?
Yes, Your Honor, and the state would rest.
Okay. Officer Tillman, you are free to go, sir. Thank you for your assistance.
Thank you, sir.
Any argument?
The state would reserve the time for closing.
Yes, Your Honor.
Mr. Lynch.
So first of all, I'd just like to address the criminal trespass and point out that there was absolutely not one piece of evidence supporting a charge of criminal trespass. There wasn't an allegation of any damage to any property. There wasn't an allegation that she was told to leave the airport and refused to leave. The state failed to meet its burden as to criminal trespass because they did not present any evidence as to that charge. So I would ask that for that reason that the criminal trespass charge be dismissed. Because again, I mean, there's several ways criminal trespass can be committed.
Mr. Lynch, I'm sorry to interrupt your argument. I heard the same thing you heard. And I'm going to ask Ms. Hernandez to address that. But as it stands, I agree with your position as it relates to the criminal trespass charge.
Okay. And thank you, Judge. I won't belabor the point then. It appears that the theory of the disorderly conduct would be uses profane language in the presence of persons under the age of 14, which threatens an immediate breach of the peace. Or I guess alternatively, it could be going under fighting words. I don't think that the evidence of any, well, there was testimony by the officer about there being children there, but there was no evidence as to, you know, what age they might have been. He just said teenagers. So I don't know if the state has presented enough evidence to go forward under that theory. And I think if it's just the fighting words, I think the context is important. There was no evidence that these words were being directed towards any of the regular patrons of the airport. And obviously when it comes, I believe there's Georgia case law that says when it comes to police officers, there's a higher standard as far as, you know, what type of language and in what conduct would rise to the level of fighting words due to their increased tolerance and training of dealing with, you know, individuals who may be using profane language. So that's the only argument I make as to disorderly conduct.
I understand. Let me ask you this question. Wouldn't the description of donkey kicking the door in the airport, wouldn't that rise to the level of disorderly conduct potentially?
Well, I certainly think that if, you know, that evidence is before the court and could be considered.
Okay. Ms. Hernandez.
Yes, Your Honor. As to the criminal trespass, Officer Tillman did testify that at the time Ms. Hart was at the rear of the precinct, kicking the door, and then he also testified that at that time the only thing she was carrying was a bag, and it did not seem like she was going, you know, on a flight or coming back from a flight. She also stated that she didn't have any other luggage at all, and that she was just standing at the location at the North Terminal Carousel, screaming profanities at everyone. And he also testified that at no time did she mention about her going on a flight or coming from a flight either. As to the disorderly conduct, as the court mentioned, she was the officer testified that she was donkey kicking the precinct door, and that at that time the officers also testified that he witnessed a lot of people there, you know, from all different ages, parents, teenagers, child, and at which time she was screaming profanities, telling FU, MF, and calling, just screaming out ho at that time. And also when the police officer tried to approach her, you know, she was just not cooperative with him. I think he describes her behavior as belligerent. Nothing further, Your Honor.
Okay. I find that there is sufficient evidence to bind over the disorderly conduct charge, the criminal trespass charge. I'm going to dismiss that. There's evidence that she was kicking the door, but there's no evidence as to damage to the door. And I didn't hear any evidence as to whether she was not lawfully there or had been told not to be there, which I think are the two ways that criminal trespass can be completed here in the state of Georgia. So I'm going to bind over to the state court the disorderly conduct charge, and I'm going to dismiss the criminal trespass charge. All right, we got Mr. Wells. Is that going to be your case also, Ms. Hernandez?
Yes, Your Honor.
Okay, and Mr. Glaze, this is your client?
That's correct, Your Honor.
Okay.
Well, right.
Yes, Ramon Lamont Wells.
Well.
Okay, sir.
Mr. Wells, sir, this is your preliminary hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm the judge presiding over your case. I want to caution you that this hearing is public, it's not private. So anything you say in this case can be used against you. So please do not discuss the facts of your case or do not say anything you would not want the whole world to know. Okay, sir?
Yes, sir.
Okay. Ms. Hernandez, would you swear in your witness and you can begin your presentation? Oh,
Yes, Your Honor.
stop. Let me stop. I keep forgetting to do this. This is the case of State of Georgia versus Ramon Lamont Wells. He's charged in warrant number 2021 WA 19527 with committing the offense of theft by taking. He's charged in warrant number 2021 WA 19528 with committing the offense of simple battery. He's also charged in warrant number 2021 WA 19529 with committing the offense of criminal trespass. And finally, he's charged in warrant number 2021 WA 19530 with committing the offense of simple assault. Okay, I'm sorry, Mr. Hernandez, go ahead.
The state would call Officer Simmons. Officer, if you can please raise your right hand so I can swear you in. Do you swear that the evidence that you shall give on this matter today shall be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Okay, you can put your hand down, ma'am. Can you state your name for the court?
My name is Treyvion Bills.
And how are you employed?
I'm employed full-time with the Clayton County Police Department.
And how long have you been employed by the Clayton County Police Department?
I've been employed with the Clayton County Police Department for about 1 year and 4 months.
And are you post-certified?
Yes, ma'am.
And do you have arrest powers?
Yes, I do.
Were you on duty on November 16th, 2021?
Yes, I was.
Do you recall being dispatched in regards to a domestic disturbance call at 5116 Highway 85? It's a hotel.
Yes, I do.
Is that here in Clayton County?
Yes, it is.
When you arrived on the scene, who did you make contact with?
I made contact with first the offender, Mr. Wells.
And could you please point him out today in court, describe what he's wearing?
He's standing right there by the hand sanitizer. He's wearing an orange jumpsuit and a white mask.
Let the record reflect that the witness has identified the defendant, Mr. Ramon Wells. Okay, officer, and when you approached the defendant, did he make any statements to you?
He made a statement that he wanted the young lady out of his room. I had asked him what happened, and initially he said nothing happened. He just wanted her out of his room.
And as part of your investigation, did you make contact with the young lady?
Yes, I did, Miss Baker.
And did she make any statements to you?
Yes, Miss Baker, she stated that while she was in the room, the offender got upset with her being on the phone. He told her to get off of the phone. He called her a couple curse words. She was saying that she was trying to charge her phone. He prevented her from charging her phone, from using the electrical outlets in the room. He used his body to keep her away from the electrical outlets. She also alleged that he had a box cutter in the bed. That he had
Officer, hold on 1 second, you're cutting off. Yeah, your internet's a little wonky. Hold on 1 second.
I'm sorry.
Okay, you're good now. You're good.
Okay.
The last thing we heard was that he had a box cutter.
Yes, she alleged that he had a box cutter in the bed, and that he had taken her cell phone and a pair of her sneakers from the room.
And do you ever return to speak to Mr. Wells?
Yes, I went back downstairs after I spoke to Ms. Baker. I went back downstairs to ask Mr. Wells a couple things about the placement of the box cutter, who the young lady was to him, and more questions about what happened.
And what did he tell you?
He said that what he said was she was claiming to be pregnant by him, but she didn't take a pregnancy test, so he didn't know if that was true. He stated that she was calling people in Detroit because family, but he never specified what types of threats that were being made. He also said that he did prevent her from using the electrical outlets because he pays the bills, like that's his room.
And did anything occur between the defendant and Ms. Hart when she was trying to plug up when she was trying to charge her phone?
So what Ms. Baker said was she attempted to use two different outlets in the room, and both times he blocked her, like he pushed her out of the way. He used his body to prevent her from using the electrical outlets. She tried to use one on one side of the room, and then she tried to use another electrical outlet on the other side of the room. And both times he blocked her from using the electrical outlets to charge her phone. She needed to charge her phone.
And did you ask the defendant what had occurred with the victim's shoes?
Yeah, I asked about you said the shoes? Yeah, he stated he didn't know anything, that he didn't move her shoes. He didn't have her phone, nothing like that.
Do you investigate that any further?
Yes, so when I went back upstairs to find out if she was finished with her statement, and I asked about the video, because she said she had him on video stating, the profanities to her and possibly having the box cutter in his hand and everything that had occurred in the room before we were called to the scene. But she said she didn't have that phone. And she said, I don't have my shoes, I don't have my phone, I don't have my phone charger. It's not in the room anymore. I don't know where he put it.
Okay, and in the video, was the defendant making any statements to?
Yeah, it was a lot, a little bit of the video, because see, what had to happen first before I saw the video was when she told me she didn't have her shoes and she didn't have her phone, I searched the second floor landing the landing, whatever floor they was on, the landing, and I searched in the garbage cans, I searched in like the little corners and anywhere somebody could hide a phone and some sneakers. And I located her phone and her sneakers in the garbage can outside of the room underneath the garbage bag. So when I gave her back her phone and her shoes, she was able to go into the phone and she was showing me little videos. The videos were really, really long. So I watched little bits of the video and I did see him there in the video, like cursing at her and using profanity and different things, like telling her to get out the room and stuff like that.
Okay. Was there any other part of the video that you saw?
It was a really long video and it was just a lot of him talking and stuff like that.
Okay, and then at that time, was the defendant placed in custody?
At the time that I viewed the video, the defendant was already placed in custody, yes.
Okay, and what was he in custody for?
The in custody for initially was for the simple battery and for the criminal trespass, because he used his body. We believed he used his body to block her from using the electrical outlets and also deprived her of access to the electrical outlets in the room that they shared together.
Okay, and then while in custody, were there any other additional charges?
While in custody, there was an additional charge because he was constantly making threats towards me. He kept saying he had like an aunt or a cousin or somebody that worked for the IRS. He kept saying, all I need is a first name, because obviously you know my last name. My last name is Officer Simmons. So he kept saying, all I need is a first name and I can get all of the information on you. He kept going on and on and on about, I left her in the room with his debit cards and his credit cards and different things like that. And if money is missing, then it's going to be my problem. Like he constantly kept making threats against me. Like it was my fault. If something happens to his possessions, then something is going to happen to me.
All right, nothing further at this time, Your Honor.
Mr. Glaze.
Yes, Your Honor. Good afternoon, Officer Nunez. My name is Joel Glaze, and I just have a few questions for you. So I want to begin. You said when you came up, you first made contact with Mr. Wells. Is that correct?
That's correct.
And during your investigation, did you do any investigation in who the room belonged to, whose name the room was in?
So the name on the room, I believed it was going to be Mr. Wells. But according to how we're trained in Georgia law, when two people reside somewhere together, it doesn't matter whose name is on the room or the lease, they have now been joined together in residency in that room or in that apartment.
Okay, and had there been at any point in that investigation, was there any line of questioning by you or any other officer that asked how long Miss Baker had been staying there with Mr. Wells?
Yes, because she initially stated that she wasn't from here, we asked, well, where are you from and how did you get here? She said, well, I'm from Detroit. I believe both of them were from Detroit. They came down here to work. And she said, he brought me down here. I'm pregnant by him and he brought me down here. And even in his own testimony, he stated that I brought her down here and she's supposed to be getting a job at Amazon, or she works at maybe another fast food restaurant. So he did also testify that they have been staying in that room together with each other.
Okay. All right. And so you charged him originally with criminal trespass for blocking her from using the electrical outlets. Is that correct?
Yes, because they both have access to the things in the room. He cannot prevent her from using the stuff in the room, the electrical outlets.
Okay. So I want to move next. You stated earlier, you testified earlier that you believed he used his body to block her from getting to those outlets. Is that correct?
That is correct.
And when you just said that he used his body to block her, how did that occur? If you know.
I'm sorry. No, you finished. I'm so sorry.
No, just how did that occur if you have an understanding? I'm not sure if you do or not, but.
So my understanding is, based on her testimony, that she was trying to plug in her phone. She's trying to plug in the charger and at one time out of the way. So that's how he came in contact with her.
So it broke up a little bit. I just want to clarify. Did you just testify that he got in between her and the outlet, or did you testify that he pushed her out of the way? I kind of missed what you said there.
What I stated was that he used his body to prevent her from plugging in her charger, and at one time snatched the charger out of the outlet.
Okay. All right. So I want to move now. At this point, you then put him in custody. And at some point, whether you were still at the hotel or not, he started making, allegedly making threats to you. Is that correct?
That is correct.
Okay. And if you could you tell me the language that he used in those threats?
The language that he used. Please specify your question a little bit more. Would you like to know what he said?
Yes, I'll go about it this way. Do you have your police report in front of you?
I do have my police report in front of me.
Okay, Officer Nunez. So I'm going to read a portion from your police report and then tell me if, this is accurate as to what it is he said, and then you can clarify from there.
Okay.
So reading from your police report, it states, if someone takes some money off of my shit, I swear to God, there's going to be an issue between me and you. It might not be today, but I'm not going to stop until I see your explicit laying. Is that your recollection of what was said?
Yes, sir.
Okay. And did you want to clarify anything else that he might have said to you?
About my ass is going to be laying? I'm so sorry to use profanity, but you want me to clarify that, or?
Was there anything else maybe that was said other than that full phrase, that full sentence?
He said that he had a cousin that worked at the IRS and he could get all of my information. And then he continued to ask me, like, where in Georgia do I live?
Okay. All right. No further questions, Your Honor.
Okay. This is interesting. I do have a question, and I'm gonna ask that question while Officer Nimmons is here. Before Mr. Glaze asked the question, I did have a concern as to the criminal trespass as it relates to the two of them staying in the hotel. That is a new one on me. Is this an extended stay hotel? What kind of place are we talking about?
So that's the question for me, sir?
Yes, ma'am.
So in our history and our experience of dealing with the OYO, or otherwise known as the Nights Inn Hotel, some tenants do stay for an extended period of time. Like, some of the units are set up for extended stay. Some are just passerby, pay by day or pay by week, however the hotel has it set up. So that really depends on the renter itself, like whoever's renting the room, how long they choose to stay.
Okay. Does anybody have any questions based upon my question? Ms. Hernandez or Mr. Glaze?
Yes, Your Honor. I wanted to see if I could, not specifically, I guess I was trying to clean it up a little bit, but not specifically to your question, some redirect.
Yes, ma'am. Go ahead.
Officer Nimmons, when you first came in contact with Miss Baker, what did she make any statements to you with regards to what the defendant had been telling her?
What she said is when I first made contact with Ms. Baker, she was in the bathroom. She was hiding in the bathroom. And that's what the notes in the call said. So that's why I left him downstairs with the other officers that responded, and I went upstairs to see about her. I asked her to come out of the bathroom, and when she began giving me her statement, what she was saying was that he was calling her all types of profanities. And at one point in time, she was kind of like undressed. I'm not going to say she was completely nude, but she was just not dressed to go outside. He opened the door and told her to get the expletive like out.
And then one more follow-up question in regards to when there was the incident where Miss Baker was trying to plug in her phone to charge, was there anything said or done at that time?
When she was trying to plug in her phone to charge her phone?
Yes.
I believe she stated that he had snatched the charger either out of the outlet. I believe it was out of the outlet, preventing her from charging her phone.
Okay. All right. Nothing further at this time, Your Honor.
Mr. Glaze, anything?
No further questions, Your Honor.
Okay. May this officer be excused?
Yes, Your Honor, and the state would arrest.
Okay. Thank you, Officer Nimmons.
Thank you.
Ma'am, you're free to go.
Okay.
Any other witnesses from either party?
No, Your Honor.
Okay. Any
None from
argument?
the defense, Your Honor.
Okay. Any argument?
The defense has argument when ready.
The state would reserve their time for closing.
Okay. Go ahead, Mr. Glaze.
Your Honor, I first want to begin by addressing the criminal trespass charge. The evidence that came out in the hearing, Your Honor, was that this was at a hotel, and that this property belonged to neither of them. Mr. Wells had a legal license to be there, as his name was under the reservation, but Miss Baker's name was not on that reservation. Miss Baker had no right to that property. That property, in fact, belongs to the hotel. This is not their residence. This is a hotel that Mr. Wells was renting. If Miss Baker came in there, she's there, but it doesn't give her the right to that property. So I would challenge, Your Honor, that even if he prevented her from using the outlets, it's not her property. She doesn't have a right to use it. If he's on the reservation for the hotel, he does have that right to keep her from using the outlets. Furthermore, Your Honor, I would like to move on to the battery charge. As far as the battery charge, Officer Nimmons testified that the officers believe that he used his body to block her. She further then testified, when I asked further questions, that he snatched the charger out of the outlet. Nowhere in her testimony did she say that he pushed her or that he rushed into her. He just simply used his body to block the outlet. So we would maintain, Your Honor, that there's no evidence that was produced in this hearing that he actually made contact with the person of Miss Baker. And lastly, Your Honor, I would like to move to the simple assault charge. The threat or the language that was used in the alleged threats towards Officer Nimmons, as she testified, was from her police report. She stated that it was if someone takes some money off of my shit, I swear to God, there's going to be an issue between me and you. It might not be today, but I'm not going to stop until I see your explicitive laying. Now, Your Honor, that's conditional future language, and under the case law, I don't believe that arises to a simple assault. Under Harrison versus State, that's 60 Georgia Appeals 610, a mere threat to commit a violent injury upon the person of another is not sufficient to constitute an assault. And I would also like to turn the court's attention to Hudson v. State, that's 135, Georgia Appeals 739. In that case, the defendant, Mr. Hudson, made a conditional future threat to go get a gun to hurt a police officer. The court held that that was not simple assault because it was a future threat. It was not immediate. It was not an immediate battery as the statute for simple assault requires. And thus, Your Honor, based off the language that Officer Nunez testified about, we would argue that this would not rise to a simple assault, and therefore that should not be bound over to state court. And lastly, Your Honor, we would just make the argument that he's in cuffs. There is no, indication that he was read his Miranda warnings, and he also has no apparent ability to inflict injury on her because he is in cuffs. He is in custody. So for that, Your Honor, we would argue that the simple assault charge, the battery charge, and the criminal trespass charge not be bound over to state court.
Ms. Hernandez?
Yes, Your Honor. With regards to the criminal trespass, Officer Simmons did testify, although it is a hotel, she said, people stay there for an extended period of time, and that the defendant and Ms. Baker had both been living together at that location for a period of time, and also that the defendant had told Miss Baker to get the F out of here, and told her to get out of the hotel room. With regard to the simple battery, Officer Nunez testified that the defendant, she said, snatched the charger, and that also she made that motion. I'm not sure if the court saw with her hand when the officer was describing that Mr. Baker attempted to block Miss Baker from charging her actual phone, making the physical contact. Furthermore, the officers also testified about that the defendant had taken the shoes from Miss Baker and possibly a phone, that it was later found, that Officer Nunez later found those items. Furthermore, in regards to the assault, the officer was in reasonable fear for her safety by the statements that were made by the defendant, where he was saying, all I need is your first name. I have a cousin that works for the IRS, saying that I swear that there'll be somebody laying. So the officer did fear for her safety, and officers' safety should not be made something of light just because the defendant is on handcuffs. Furthermore, there was also a mention about a box cutter that the defendant had on him, and that the Miss Baker witnessed the defendant with the box cutter and was and had it open and in his hand. Nothing further, Your Honor.
Let me ask a couple questions. The alleged victim for the simple assault is Officer Nunez.
Based on the report, I think so.
Okay. So the theft by taking is an easy case that's going to get bound over to the state court. The criminal trespass and the simple battery are the more difficult. I'm sorry, the simple assault are the more difficult cases. The criminal trespass, hypothetically, I come in, rent a hotel room, and I go out at a nightclub and I meet someone, and the person comes back to the hotel room with me. I don't see how that person has, or presumably can have, interest within that hotel room to the extent that that person can't be forced to leave if I say so. And let's say it's a week, it's extended stay hotel, and the person's going to stay with me. The plan for me, hopefully, is stay with that person the whole week. But 2 days in, I get tired of that person, and I tell them to leave. I don't, unless there's something else that you can show me, Ms. Hernandez. I don't know if that person has the type of possessory interest in that hotel room that the state of Georgia would recognize under a public policy standpoint. I understand with the dispossessory laws as it relates to people having, that there's a public policy that recognizes that if you invite somebody to come and live with you, that person then has an expectation of the right to use the property, possess the property, just like as if they were the owner. And if that person is there with no end date set, that person can then gain a possessory interest where the homeowner or landowner would have to kick the person out. The argument, Mr. Glaze, as it relates to the fact that neither one of them own it, if you're in an apartment complex, neither one of the people who are renting the apartment owns the complex. So I'm not reasoning this through that lens, but a hotel, I think, is a little bit different. So my ruling will be that I'm going to bind over the theft by taking and simple battery counts. I'm going to dismiss the criminal trespass and the simple assault counts. And Mr. Glaze, you get the honor of writing that up.
Will do, Your Honor.
Thank you. Is that it for today? I don't see any other cases.
I believe so, Your Honor, unless the jail has someone else.
Mr. Wells, you can.
Yeah. Well, I didn't hear what happened. I'm going to jail, bonded over. Or...
I'm going to dismiss the criminal trespass and the simple assault charges, but I'm binding over the theft by taking and the simple battery.
So,
okay.
Yes, sir. Anybody else?
I don't believe we have anybody else.
Did we address Mr. Collins? I'm sorry, I couldn't remember.
CS1. We did that announcement from Mr. Collins. If I'm not mistaken, he had.
Oh, there is a waiver. I have on my notes that there is a waiver for Mr. Collins. Or that will be a waiver.
Thank you. I just kind of forgot what had happened with that case.
Okay. Ms. Ponder, did my notes match with your notes?
That is correct, Your Honor. I believe, and I had asked for both officers to be excused. I think we had Officer LaRotney.
Yes,
And I asked for both witnesses to be excused once that announcement was given by Ms. Gross.
yes.
Your Honor, this is the jail. Can you advise case inmate Stern?
Mr. Stern, his case is going to be continued, so he can be sent back.
Yes, sir. Thank you.
Okay. So is that it?
I believe so.
All right. So I'll wait for the orders that I haven't received, and I'll be processing those for the rest of the day. Is there anything else?
Judge, I have a question.
Yes, sir.
I apologize if you already answered this, but on the cases for which they were, Your Honor, found probable cause as to all of the offenses, do we need to submit bind over orders for those cases as well?
No, Ms. Gross sent me a template of the bind overs. So I have been making my notes, and I will do those and send those over and make sure that I copy everybody that's involved.
Thank you, Judge.
You're welcome. Anything else? Okay. Well, thank you all for your assistance. It's been a long day. I got some more work to do, but if there are no more questions, I'm gonna end this hearing.
It was nice to meet you, Your Honor.
Yes, ma'am.
It was nice to meet you.
Oh, it's nice to meet you too, Ms. Hernandez. Everyone have a good day. Stay safe.